Stand, please. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-5009, Animal Legal Defense Fund, Inc., appellant versus Thomas J. Vilsack, Secretary, United States Department of Agriculture, et al. Mr. Waltz for the appellant, Mr. White for the appellees.
Good morning, counsel. Mr. Waltz, please proceed when you're ready.
Morning. I'm Danny Waltz on behalf of Plaintiff Animal Legal Defense Fund. ALDF brought this case on behalf of its members, including Marie Mastracco, an unwitting consumer who regularly bought misleading Purdue chicken products that the government failed to review. She has a genuine interest in continuing to buy raw chicken products for her elderly dog, and because of the government's failure to review label imagery, she cannot have confidence in any of the chicken product labels that she must buy. District Court.
What about written claims? I thought that the challenge here was limited to graphic claims.
No, it's not, Your Honor. The challenge is a pattern and practice claim based off of the agency's failure to approve or review and properly approve claims that Purdue fresh line claims, which confuse Mastracco on both the textual grounds and the imagery grounds, as well as the agency's failure to review imagery altogether.
Imagery meaning words?
Imagery. So the PPIA doesn't really distinguish within labels. Label is to be reviewed holistically. That includes both the graphic imagery and the text itself. And so when I say imagery, I'm sorry, I mean the graphics on labels. That would be the chickens that are outside under the sun, as opposed to words like cage-free, both of which misled Mastracco when she purchased the fresh line products.
But I thought the upshot of the complaint was that the problem that's seen is that there's not a review of the graphics. And because there's not a review of the graphics, there's no way to look at the pictures and get an accurate sense of whether the pictures are giving you the real world. And because the pictures aren't giving you the real world, with respect to labels other than the Purdue labels that are directly an issue, the second claim is about a general confusion and an inability to figure out what the real world is. And so essentially a decisional paralysis that doesn't allow her to make an informed assessment of which products to buy to make sure that the chickens are being raised in a way that is commensurate with her beliefs, because you can't tell from the pictures whether that's in fact the case. So isn't it about the injury comes from the lack of review of the pictures? So the claim is about the pictures.
The injury, and yes, I would agree with most of what you're saying, Your Honor. I think the injury and the claim are both cover or deal with both the sort of interplay of the text and the imagery. It's under the PPIA, Congress really sought to define label broadly to include both the imagery and the text, and sought to protect consumers from false and misleading claims that the government fails to review properly. And so when you're looking at the injury, I think you're looking at the holistically label, and the imagery. Black letter consumer law says that I think in the words of the Second Circuit, consumers aren't required to do this disputatious dissection of labels to figure out what aspects of labels are proper or maybe accurate, what aspects of the labels are inaccurate, and weigh those against each other to avoid injury or to avoid having that consumer harm. And I think that's what the government on appeal is asking Ms. Mastracco to do. They're asking for her to be able to read certain aspects of ignore the imagery on a label that the producers are putting on there sort of like a siren song to attract consumers to the label, and know that that may be misleading, but focus entirely on the text. That's not what consumer case law requires. It's also not manageable.
Can I ask you this? So suppose, I know you'll resist that this is the real world, but just assume for purposes of the hypothetical, this is the real world, that there's no other chicken product on the shelves that has a picture. It doesn't have a picture at all. It's got words, they have words, but they just don't have pictures. If there's no other product that has a picture, and there's no allegation in the complaint that there is another product that has a picture, would she still state an injury?
I think so, Your Honor. No, you're saying no other because she does still have access to the Purdue products.
Oh, yeah, sorry. Thanks for the further refinement. I'm talking about the injury that stems from the inability to suss out whether the non-Purdue products are involve chickens that are raised in a manner that she finds consistent with her beliefs.
But I don't think that there needs to be an allegation of another product available to her aside from the Purdue products, because pursuant to Davidson, but she would just be like the Davidson plaintiff, someone who is interested in a product, otherwise wants to buy that product, was misled.
Right, but I'm assuming that just for purposes of this, I'm assuming that the injury she's claiming is not that she might buy again by Purdue. And so she could be misled again about the same label by which she's already been misled. But her claim is only about non-Purdue labels. And on that, if there's no other product that has a graphic that includes a picture at all, would she still be stating an injury as to that part of it? Not as to that I might buy another Purdue product and therefore I might be injured again because I'm misled by Purdue, that I have an injury based on the non-Purdue labels, given that the government doesn't review the picture on the Purdue label in the way that they should have. Is she stating a claim as to the other non-Purdue labels if in fact there's no other non-Purdue label that has a picture at all?
Well, it's hard to envision a world where there is no other situation where she walks into a grocery store and there's no imagery on there. I think she has a lack of, now that she knows that there's a lack of, the government is failing to fully adequately review labels, in part because of its failure to review the imagery, but also because of her experience with the government allowing the Purdue labels to pass through its review, including the terminology cage-free. While that being, I think, we have in the complaint that 1 in 3 consumers is misled by that label. She doesn't have any confidence in.
What was that? Did you just say that it wasn't really highlighted in the complaint that cage-free was misleading?
No, sorry. 1 in 3, as we allege in the complaint, we had a consumer expert do a survey and found that 1 in 3 consumers found the Purdue labels to be misleading. And that was because of, as Mastracco alleged, just like Mastracco, a combination of the cage-free textual terminology and the imagery. The interplay of those together caused.
What rides on your argument that it's the interplay of the text and the imagery? I mean, put aside for a minute the government's third argument that, consumers can avoid any misleading effect of imagery by just relying solely on the text. Assume we don't accept that argument. Why are you making this this is not what I understood from your brief to be your argument, this interplay argument. I thought the point was, even without any claim about free range or free roam, that the imagery on the Purdue labels implied that the chickens were actually raised out of doors with sun and grass and freedom to move around, and that was an implication that arose from the image. Is that not your position?
That is the position. So I think what the government should do is that when reviewing labels is look at the labels holistically. That includes both text and imagery. But yes, the imagery of the chickens outside on the grass under the sun does give the strong inference that the chickens were raised outside, when in fact they were not. And that's an sort of arbitrary and capricious claim we expect to succeed on. Should we be able to make that merits argument? But to go to this whole back to the government's argument that Ms. Straka may rely on the text, I just sort of want to take a step back and sort of question what they're arguing, which is seems to be putting a significant burden on the consumer to have to figure out what potholes to avoid, not paying attention. Don't pay attention to the text. Excuse me, to the imagery. Don't pay attention to certain text that's already confused you. And then consumer must need to read the Federal Register to fully understand what all the textual claims may be, so that she may not be avoid. The Poultry Products Inspection Act doesn't put that burden on the consumer. It actually puts it on the government.
So does your claim depend on us accepting the approach of Davidson?
No, Your Honor. I think that there are the TransUnion, for example, identifies economic injury as a tangible concrete interest. She has had Straka has had economic injury.
What is the alleged economic injury?
She's had she sought to purchase a product that aligned with her values, that she perceived aligned with her values, and was misled and didn't get the benefit of her bargain. And
you describe that as ethical. It doesn't seem as so. What about? I mean, it seems to me one way to have standing in a case like this for future injury is, and I'm thinking a little bit about the facts of like the Johnson & Johnson case, and although the majority rejects this analysis, but if a competitor of Purdue, let's say a competitor that does actually have free roam or free range chickens and uses a similar imagery on their package to Purdue's fresh line imagery, and they charge a similar price, but looking at the two side by side in the grocery store, consumers, or maybe, Purdue charges slightly less. So the consumers see that as a commensurate product, and they buy Purdue's fresh line product over the one that's much more expensive to produce and actually a different kind of product. So in that situation, it seems that the competitor would have standing because the price of Purdue's product is artificially inflated. I don't take you to be alleging that harm is present in this case, although I'm unclear why you aren't alleging that. For example, even though, we have this catch-22 situation where as soon as a potential plaintiff is aware that something's misleading, she's no longer misled, and therefore how can she claim she would rely on that in the future? But it seems like this competitor standing type analysis could be applicable in a non-competitor case like this. If the plaintiff says, I'm aware now, but the rest of the world isn't, and I have to buy something, and even if I'm going to tolerate the inferior product and buy Purdue, I'm paying too much for what it is. I don't see that alleged in your.
Yeah, I think we do argue that with the line of lost opportunity cases, I think Orangeburg cases, which is the hypothetical you just presented of the competitor out there who is actually adhering to the practices that are on the label, unlike the humane washing company. Ms. Straka doesn't know that alternative product is necessarily accurate, but it may be, as you just said, and she has injury not only from being, the choice is either, in this situation, purchase a product that she may she believes meets with her preferences, but doesn't, and so she doesn't get the benefit of her bargain. Or she foregoes. Alternative, she foregoes a product that she does want to buy, and because of the government's failed regulation, she's the lost opportunity to access products that she prefers.
But even without an alternative product, the same economics would obtain if Purdue is differentiating its fresh line from some other ordinary and charging more, but really all that's improved about the fresh line is that it's got a prettier label that actually is misleading enough to make people pay a premium. You don't need a competitor in the market to make that claim, but I don't take you to be making that claim here. When you say she believes it, like she now knows that Purdue's product doesn't perform as she wants. And whatever ethical injury that may cause her, it doesn't seem to me to be tied to misrepresentation. And so it doesn't seem like a harm that's necessarily caused or redressable.
Well, I see that as a consumer confusion injury as opposed to some sort of ethical injury. So she's
no longer confused on count one. She's no longer confused vis-a-vis Purdue.
Right, as to Purdue, she's not, but she is to the other products that are out there in the market. And in fact, actually, I would disagree. I'm not sure she is no longer confused to Purdue. What she knows is that, it's just as in Davidson, she knows that she doesn't know. She knows that this product is the result of certain practices, but Purdue's. I think we have in the complaint that the Purdue's website says that it is moving towards chickens with raised in outdoor conditions. In fact, 25% of the chickens in its pipeline are raised outdoors. And so there may be a point in time when the label is accurate, or at least is accurate in a way that is consistent with her, what she prefers. And so but she will never know whether she can rely on it. And we'll have that ongoing consumer.
Let's just focus on the time aspect of this, and this building on what some of the back and forth with Judge Pillard. This is a frustrated consumer. She bought the product in the past. She alleges that she was misled, and that would clearly give her standing to seek some kind of backward-looking traditional consumer protection action. This case is all about forward-looking. So you've said this a couple of times, but walk me through exactly what is her future injury that would be redressed by an order taking this label off the product. She knows everything she needs to know. She knows that the product doesn't conform to how she would like animals to be treated. And she knows the government doesn't review the cartoon. So, right, it's as if the cartoon just doesn't mean anything. She knows all that. How is she better off if the label, the cartoon comes off the
label? She's better off. So first, a couple of things. She unfortunately cannot seek backward-looking,
right,
thanks to the preemption provision.
Right. But you need standing for. You need a separate theory of standing for forward-looking.
That's right. And the way in which her injury would be redressed by a court order that the government review labels is that if the government starts reviewing imagery on labels, then and it does so through its pre-market approval process, products that are misleading, or all of a sudden imagery that's misleading gets weeded out, doesn't make it through the government's pre-approval process, and those that are not misleading or that are accurate, where the applications submitted includes evidence showing that the chickens are raised outdoors, those will make it through. And so she loses this consumer confusion, this lack of confidence that Judge Pillard and I were just discussing, because everything that's out there, she should have confidence. It comes from chickens who are raised outdoors.
How is that harm concrete? Can you describe how it would change her value proposition or her purchasing behavior? You would allege that she will continue in the existing market to buy chicken breasts.
Yeah, yes. Right. So she's, we allege that, so unlike some of the other cases, the government sites or even that support our position, I think that her compulsion to buy chicken breasts for her dog is much stronger than what we see in other circumstances with other consumers.
Right.
So,
There's a certain ways, but it's unhelpful in another way, which is what is the concrete benefit to her other than dispelling confusion? Can you make that more concrete in terms of a different purchasing decision or some value?
Well, she has more certainty that the purchasing decision that she makes is going to be accurate, and she will not risk. So it's almost like an increased probability of certainty. The circumstance that she's in now, I think we were discussing, is that she will either buy a product that that comes from practices she abhors without knowing it, or with knowing it if she feels like she has to only buy the Purdue product, or she's buying a product, or she's foregoing a product. She has the risk of foregoing a product that she may value. That there's this risk that will happen. I mean, she may get lucky and buy a product that is accurate, but that's she still has ongoing consumer confusion there. So the court order that would force a government to review labels would increase the probability that she's making accurate purchases.
Judicial review here is just through the APA, right?
Yes.
DPIA cause of action is for others, right? So you need a discrete agency action that's either final or unlawfully withheld. How do you get the right to, you said a pattern and practice claim that would globally require the agency to review labels. How do you get that through the APA? I would think the most you could get is something specific to Purdue.
We have in the record, we have, after submitting the ALDF had submitted a request.
I'm sorry, who?
ALDF had submitted a request with the agency to deny Purdue labels, sort of its pattern of constant approval of Purdue labels. And the agency's response was that it does not review imagery at all on labels. And so, as part of that, that was central, I think, to the agency's decision to continue approving Purdue labels. And so what we'd expect from a court order would be that practice is an order that practice of ignoring or not paying attention to imagery is unlawful.
And the agency action or inaction, specific action?
The approvals of the labels.
Without looking at the graphics.
Yes, exactly.
So just to make sure that I'm not confused about your consumer confusion rationale, because as I understood it, your response to the questions about what's the forward-looking injury is not about the forward-looking injury vis-a-vis the Purdue label. I mean, you may have a Davidson kind of argument about that, but let's just put that to one side. Your focus is, no, there's confusion because the lack of review of the graphics of the labels means that she can't look at the other labels and be sure that their images are accurately portraying the way in which the chickens are are not allowed to be outside.
Yes.
And as to that, in order to have that injury, I'm just going back to where I was at the beginning, we have to assume that there's other labels that in fact depict chickens being outside. Because if there are none of those, then there's no, the remedy can't help her, because if there are no other images like that, then she's not confused by anything that's out there in a way that's going to be redressed by what you're asking the agency to be required to do.
Yes, I think that's right. Setting aside the Purdue.
Right. Putting aside the Purdue, for the consumer confusion one, which is looking beyond Purdue to other labels, there has to be other labels that in fact contain a graphic that depicts chickens being outside. And if there were, then I take your point that then at that point, if she thinks that the agency is falling asleep at the switch and they ought to be reviewing those and aren't, then she could look at the labels and think, I'm confused. I don't know whether to trust the image on this.
Mhm.
It may or may not be accurate. I really care about whether it's accurate because I really care about only buying chickens that are allowed to roam outside. But I can't look at this picture and know whether it's in fact accurate. But if there are no other such pictures, then there's no injury.
Yes, Your Honor. I think that's right. I think we allege at paragraph 34 that she's going to suffer a lack of confidence in whether there are any chicken labels that convey accurate descriptions of the product's animal raising conditions. So we think that sort of is broad enough to encompass those other labels that are out there on the market.
But it doesn't say that there are such labels.
No, Your Honor. But I think any stroll down a supermarket aisle will make clear that there are. Also, it's a bit confusing just to even know, to try to define what that type of label is. I'm thinking of chicken labels where the name itself also is of a chicken or is of, there are labels out there that will say like naked chicken and it will be done in imagery that is of leaves. And so is that an image or is that text or is it both? It's really hard to disentangle the two. And I think that's part of the reason why Congress defined label to include both text and imagery. That said, if that's a needed allegation, that's something that we absolutely could add in. I don't have any concern.
All right. Why don't we give the government a chance and we'll give you a little bit of time to rebuttal.
Thanks. Thank you very much.
Mr. White.
Thank you, Your Honor, and may it please the court. Graham White for the government. The district court correctly held that plaintiff lacks associational standing because the complaint does not allege that any of plaintiff's members are likely to suffer a substantial risk of future injury. Let me just say at the outset in response to some of the questions that were just raised as a point of clarification, this case is about imagery. It's not about the written text. The complaint is not alleging that the government fails to regulate written text here. It's alleging that the government is not reviewing imagery. And while we very much dispute that that's the case, the complaint is alleging is that Mistraco lacks confidence in animal raising imagery. And the reason these allegations are insufficient is because the complaint does not allege that Mistraco is certain or even likely to encounter this kind of imagery going forward. The complaint does not allege that she has any desire to purchase this particular product again. It doesn't allege that there are other kinds of products out there that have animal raising imagery, much less that there are enough of these products on the market that the risk of encountering them and having some kind of confusion is substantial.
So about that, you've heard a couple of exchanges about whether there are such other products. And I think I understand your argument that regardless of whether there are or aren't, there's nothing in the complaint that suggests that there are. And if there's nothing in the complaint that suggests that there are, then when you look at the four corners of the complaint, that kind of consumer confusion injury isn't made out. But what's wrong with the response that, well, that allegation would be easy to make. There in fact are such products. All we would need is just an opportunity to amend the complaint to add one allegation that makes that out, and it's actually true that exists in the marketplace.
Sure. So a couple of responses. First, we're not disputing that it's possible that there are these products, there are other products out there. The standard to get injunctive relief here is that the harm is certainly impending. So there have to be enough of these products out there that there's actually a substantial risk. But in terms of what we can add to the complaint, what they can add to the complaint, what they can't. The district court here dismissed the allegations without prejudice, so they're free to file this claim again if they want to. I will say that they've already amended their complaint once. But whether they are given leave to amend again or whether they file a new lawsuit with these allegations, it makes no difference to us.
So if it doesn't make any difference to you, then you wouldn't have a problem with them being given leave to amend because they could just as easily file a new complaint. As you point out, it was without prejudice.
Right. It wouldn't make a difference because
from your perspective, it doesn't matter.
It would not. Let me just point out a few issues here with the allegations in this complaint. One other problem here is that the complaint doesn't allege what kind of imagery Mastracco would find confusing on other product labels going forward. I mean, in this particular case, the complaint alleges that Mastracco was confused by imagery of chickens on a farm in conjunction with some written text saying cage-free. But it doesn't allege that she would have misinterpreted the label in the absence of that written text. And so going forward, whether she's going to potentially misinterpret a label is going to depend a lot on what the label looks like. It'll depend on what the images looks like. It will depend on a number of contextual clues on the label itself. So I think that just goes to show that the image here, the injury here that's being alleged is pretty speculative here because we're talking about hypothetical products that we don't know exist. And let me also just add that even if Mastracco was likely to encounter a product that has animal raising imagery on it, a consumer's lack of confidence in the imagery itself is not by itself a concrete injury. That's not what the Ninth Circuit said in Davidson. What the Ninth Circuit said in Davidson is that a lack of confidence in a label can lead to an injury under certain circumstances. If, for example, a consumer refrains from buying a desired product because they can't trust the representation, or if the consumer buys a product in reliance on a representation that turns out to be false, in which case they're duped. But if a consumer lacks confidence in a label, buys the product, and it conforms to their expectations, they haven't suffered concrete injury. So I think that's another potential flaw here in the standing analysis, standing argument that plaintiffs are raising here.
But you say that that it can lead to concrete injury because the consumer might refrain from purchasing. With respect to count one, she's alleged, or they've alleged that their member has refrained from buying the Purdue product, and they claim that that's enough harm. What's your position on why that's not enough harm?
Well, so I don't think that the complaint alleges, in terms of her behavior going forward, that doesn't say anything about Purdue. I mean, I think you can infer that
that she has to buy chicken, even if
Right.
it's not perfect by her own standards. And it may be that it's sometimes Purdue, for other reasons, is going to be the preferable choice, but she's still subjected to this. I mean, what
Right.
about the notion that she's also probably paying a premium for that product?
Paying a premium.
Unwarranted premium for that product. It's made to look like a more animal-friendly product than it is.
Well, I think, the complaint doesn't contain any allegations about what she's paying for these products or if she's paying premium or anything like that. But I would say, in terms of whether she's going to refrain from buying Purdue in the future, part of what makes this case different from Davidson and some of the other cases that the plaintiff relies on is that the plaintiff here isn't alleging any desire to buy a particular product. He doesn't care if she buys Purdue or not. She just alleges that she wants chicken breast products for her dog. So whether she is ultimately deprived of the opportunity to buy Purdue again doesn't really seem like a concrete injury in the same way that it was in Davidson, because whether she buys Purdue or something else, I think doesn't make a particular difference to her.
It didn't to the plaintiffs in Davidson either, did it?
I'm sorry?
It didn't matter to the plaintiffs in Davidson either. They were also looking for a type of product, a flushable,
Right. Well,
and they were unable to find it.
I think the plaintiff in Davidson alleged that they wanted to buy the particular defendant's product, and because it was flushable, that they would buy the product again if given the opportunity, and that they were frequently that the consumer plaintiff was frequently in a position where she would be confronted that product again.
So too here, she's going to the supermarket,
Well,
looking for a product that she feels compelled to buy, even if it's non-ideal. And here, in a way, it's stronger than Davidson. I mean, one of the weak points of Davidson is why should she think that suddenly why should the consumer in that case think that the company had made the product conforming, whereas here, as Mr. Waltz has pointed out, Purdue has made assertions that are in the complaint that they are trying to conform more to the implicit message of the graphic. So why isn't the same harm here that even though on the one hand, she's been disabused of, she knows that the claim was misleading, at least at one point. Why isn't it fair for her to think, well, it might no longer?
So I think a couple of responses. First, I think I would take issue with the premise that this case is as strong as Davidson. There are a couple of critical allegations in Davidson that were essential to the Ninth Circuit's holding that were not made here. Number one, as I mentioned at the outset, the plaintiff does not allege that she wants to buy Purdue products again. Number two, unlike in Davidson, the plaintiff is not alleging here that she'll encounter this kind of product when she goes to the grocery store, or that the complaint supplies no factual basis to think that she would encounter this product or any other products that have the potential to confuse her. And unlike in Davidson, she does have a way of determining whether the product conforms to her consumer preferences. She can read the written text on the label.
That is a tough argument. I mean, the FSIS is statutorily required to review the graphics as well as other things.
That's right.
And I mean, we have this case, Span versus Colonial Village, that has to do with depictions in real estate ads, and they're depictions of only white people at a complex. And so the potential purchaser is deterred. And you can't say, well, just avoid those products. I mean, that can't be right to say that she should just avoid a product that has an unreviewed, misleading label and only go with things with the text.
So that's not exactly what we're saying here. I think what the complaint is alleging is that there are Purdue products that do conform to Mistraco's consumer preferences because they are labeled organic or free range. That means that the chickens were raised outdoors as Mistraco wants. So if she doesn't have to avoid a product, if she wants to buy the Purdue chicken product, she can just buy the ones that say organic or free range or outside. But I would also just note that this is not this particular sub-argument is not, the court doesn't really need to go there. I mean, it's enough that the allegations here are too speculative and that the asserted injury is not concrete because she's not alleging any sort of downstream consequences that flow from her purported lack of confidence.
I'm not sure I understand what's speculative about it. If put aside the text response for now, that she could just look at the text. But you said even independent of that argument is still speculative. If there's an allegation in there, suppose the complaint is meant to add an allegation that says there's a multitude of chicken products out there at the grocery store that show chickens in graphics that look like they're outside. So they make me think that they're being raised in the way that I think is appropriate. And so I'm tempted to buy them. But the government just isn't policing those graphics to know whether that's accurate or not. So I just have decisional paralysis. Yes, I'm going to buy something because my dog needs chickens, but I'm buying them without knowing whether it's actually true that what the graphic tells me about the way they're being raised is in fact the case. And if the government did its job, then I wouldn't face that tension and uncertainty and anxiety that I now face. What's wrong? Why isn't that perfectly okay as an injury?
So I see that I'm out of time.
Yes.
Can I answer? So it's still speculative because, as I noted at the outset, Mistraco is not, the ALDF is not alleging what kind of imagery she would find confusing in the first place. It's not even clear from the complaint that she would have misinterpreted the animal raising imagery in the absence of the written text cage-free. So whether there are other products out there that have chickens on a farm, that doesn't necessarily mean that she's going to be confused about the product. I mean, it could be imagery that's very realistic. It could be it's not. I mean, it's possible that she would encounter a product that confuses her, but not likely based on the allegations in the complaint.
What if we disagree and we're willing to read the complaint a little bit more liberally than your suggestion? And the cage-free is an aspect, but really she's seeing this picture, and the simple inference that she draws is these chickens are raised outside. And indeed, it may be that she's looking for something more than free range, because maybe free range is sort of, a very limited amount of roaming, whereas this picture shows, old school chickens sort of running around freely. It may be that one of the, as I read her complaint, one of the points that she's making is that a graphic can make claims that don't fit in to one of the standardized and scrutinized claims like organic or free range. There's suggestions that she's saying free roam is something broader than free range. And it's not a defined term textually, but it's a projection from this image. And to that extent, it seems like, first of all, it underscores the importance of potentially reviewing the graphic. And second of all, it's in tension with the notion that she can satisfy herself by limiting her review to the text.
Yeah, so a couple of responses. First, I don't want to get out in front of my skis on this, but we dispute that the government does not review the graphics. But that aside,
We dispute.
we dispute that the government does not review the graphics as alleged.
Oh, you do dispute
Yes.
that? Oh,
The inspection services regulations require it. We haven't gotten to that aspect of the litigation, right? We're just in the pleading. So I'm assuming for the sake of this appeal that the allegations of the complaint are correct. But getting to your question, even if we were to construe the complaint liberally, as you were saying, and even if we add the allegations or to amend the complaint and add some of the allegations that Judge Srinivasan was suggesting, it still would not be enough because the plaintiff is not alleging any concrete injury. She's not alleging that she's going to refrain from buying a product because she doesn't know whether it was raised outdoors or not. That's not what the complaint says. It just says that going forward, she feels compelled to buy chicken breast products for her dog. It sounds like she'll buy the products no matter what. Nothing in the complaint supports the inference that this is affecting her decision-making process in any way.
But that doesn't seem quite fair because she's going to be influenced in which product to choose. Something that tends to show sunlight and valleys with chickens out of doors versus something that's just text and looks quite generic, and she can assume the grimmest of circumstances that she's making choices in a market with lots of different options, and she's saying this imagery is misleading. And the fact that it's not being scrutinized for that, at least as she's alleging.
I think we are at the point where we're potentially adding some things into the complaint that aren't there and maybe construing it a little bit beyond what the plaintiffs are saying here. At the end of the day, the complaint really supplies no factual basis to think that she's going to encounter any product like this Purdue product that has animal raising imagery. There's just no factual.
Right. So if we assume that allegation were added, I'm still not quite getting it. So suppose that we're only talking about graphics and we're only talking about confusion from graphics. And her point is, and just imagine this complaint exists, and we can talk about whether this in fact is commensurate with what's in the complaint, but let's just imagine the complaint that does say this. I want to be sure when I buy a product that the chickens were allowed to go outside. And the way I make sure of that is I look at the graphics. And the graphics indicate that the chickens were allowed to go outside, and therefore I'm feeling good about it. If I don't have any certainty that the graphics are accurate, then I'm not certain about whether they in fact were allowed to go outside. That causes me some angst because I don't know that the chickens were raised in a way that I think is okay. If the government did its job, I would be sure of that. That's my injury. I'm either unsure or I'm sure. And I'd rather be sure than unsure because I really care about this. It really matters to me. That's not a cognizable?
That is not a concrete injury under Article 3. And I don't think that Davidson or any of the cases that the plaintiff relies on says that is a concrete injury in and of itself. I think it would be different if the plaintiff is alleging that she really wanted to buy Purdue or another particular product and she is refraining from doing so, or if she ends up buying a hypothetical product in reliance on the imagery or lacks confidence and it turns out not to conform to her expectations. That's another possibility of a concrete injury. But the angst that you're referring to by itself, that's just not a concrete injury. And the plaintiffs have not identified any case that says that it would.
Why not? It seems like it's sort of in between the traditional injury of a defrauded plaintiff. If you got certain information, you would be misled. And let me just put something on the table. It's sort of in between that and the informational injury sort of situation where the plaintiff says, I want more information. So like I to get the misleading information or I want some truthful information. And this is a little bit of both.
So I think a couple of responses, Judge Katsas. First, the Supreme Court has said in TransUnion that an informational injury unaccompanied by adverse effects is not enough for Article 3. And in terms of traditionally what kind of injuries consumers have with misled, who are allegedly misled, very often is the case. Courts have held that consumers can have standing when they will rely on a misrepresentation on a label to their detriment, purchase the item and get duped. So there is some kind of like concrete injury that's actually happening here. I don't think. I haven't seen a case that is really suggesting that just the angst that Ms. Jocko allegedly feels it would be sufficient by itself.
In the real world, it just seems like she is worse off because injury means are you worse off? And you are worse off if you buy a product, if you're compelled to buy a product because your dog needs to be fed. You are worse off if you don't know whether the product is commensurate with your values than if you do know that it is.
But if the product actually is commensurate with her values, then she's not worse off. In other words, like if she ends up buying a competitor's product, lacking confidence in whether the chickens were raised outdoors, and the chickens were raised outdoors, I don't think you can say that she's really worse off in any meaningful sense. And again, I think that's why it sort of invites some speculation as to her asserted injury in connection with other products that we don't know whether they exist and whether they accurately reflect the chickens raising conditions.
But she doesn't know whether the product, I mean, yeah, I think if you assume that the product was accurate, the label was accurate, the image was accurate, then it may turn out that her fears are not well-founded. But the point is she doesn't know.
The point is she doesn't know, but as long as there's no sort of concrete effect associated with her, it's not.
So back to TransUnion for a second. If you don't have a statutory right to specific information, informational injury is not concrete, absent a downstream effect. But here, this isn't the classic non-standing situation where the plaintiff wants information because he or she is upset with how the executive branch is running itself. She wants information to inform a purchasing decision. And why isn't that the downstream?
Well, because there's no allegation that she won't, there's not a plausible allegation that she won't get the information going forward. I think it's.
Well, the allegation is, and you've said that in fact, this isn't the government's position, but in the letter that is referenced in the complaint, she understands the government to take the position that they don't review imagery on labels for the claims that they may implicitly convey. And if that's true, then she does have a reasonable basis for thinking that she can't rely on imagery.
But it doesn't plausibly allege that she'll be in a situation where she can't rely on the imagery because we don't have any basis from the complaint to think that she's going to, that the complaint is sort of assuming that when Ms. Mastrago goes to their grocery store, that she's going to be surrounded by a lot of chicken products with cartoons of chickens on farms, and that she won't have any basis for distinguishing between them. But there's no basis in the complaint for getting there. I mean, we don't know.
So it's the lack of allegations of imagery on competitor products labels.
Among other things, that shows that there's no substantial risk of her actually having this problem when she goes to the grocery store. I mean, it's very possible that she could go to the grocery store and there are no chicken products that have animal raising imagery on them, in which case.
So it's helpful to bring it down that one level of concreteness and say that it's the lack of allegations that there are other labels with pictures on them. What about the economic argument that I did not see raised in the, I guess I have two sort of related questions. And really the broader question is, a lot of the cases say what you also argue, which is, and once the scales have fallen from her eyes and she knows that, bracketing whether it's actually misleading, but she knows that the label is in her understanding misleading, then she lacks standing going forward, at least with respect to that product, because she's no longer misled. There's something very odd about a standing doctrine that deprives people who are subjected to deception from challenging the reason that deception might be ongoing. And I guess my broad question is, what's your response to that? And my narrower question is, do you have a response to the economic injury questions that I was posing to Mr. Waltz? Why can't we assume, as a matter of basic economic logic, that to the extent that these Purdue Fresh labels convey an impression that these chickens are raised outside, people are paying an unearned premium for this product, including potentially this plaintiff going forward, because she may know that it's misleading, but others don't?
I think it's hard.
It's a lot of questions, I know.
Yeah, I mean, let me sort of start with, I think the first question you asked in terms of, we very much disagree with the premise of the argument that my friend on the other side is making, that if Ms. Mastracco does not have standing, then no consumer would have standing. We are not saying that there are no set of facts under which a consumer could potentially have standing to seek injunctive relief here. What we're saying is that even under the cases that the plaintiff cites, the allegations here are just woefully short.
And what would be the kind of, I mean, partly just thinking about whether this makes any sense, what would be the kind of situation in which there could be, I mean, let's say for purposes of argument that the government isn't reviewing any graphic imagery and somebody wants to bring a case to trigger a ruling on whether they need to. How would that be teed up?
Well, I think even the allegations in Davidson could provide at least a benchmark for what could conceivably get you over the line. But even in that case, the Ninth Circuit held that it was a very close question. And so allegations that are similar to Davidson maybe could, if the plaintiff is alleging facts to show that she is likely to encounter the product again, and that she has no way of knowing whether the product conforms to her expectations or not, and that she would suffer some kind of concrete injury from either not buying the product as she wants to or buying it and it turns out to be false. I think those are allegations that maybe could get you there. But again, the complaint here doesn't even get close to that. So I think it would be enough to affirm just for this court to say, even if Davidson were to apply, the allegations don't come close to there, and there's no need to issue any kind of broad ruling that would categorically shut the door on consumers. That's not what we're asking for. I think it's just the allegations of this complaint just do not come up to the level of Davidson or any other cases.
Can I get back to this question about the kind of the consumer confusion rationale that, let's suppose that there's a complaint that adds the allegations that we were just talking about that you say are missing, which is that there are in fact other products out there that contain graphics that indicate the chickens are outside. And the ostensible lack of review of those graphics gives me pause because I can't look at these various labels and make an informed decision. And you're saying that that's missing, but if we say that that's there or that they were allowed to amend the complaint to put that there, then you're saying that still wouldn't be enough because that kind of injury isn't an Article 3 injury. So if that's true, then there's a lot of people who care about labels on food to make sure that the way the food is prepared is consistent with their faith. And so if somebody says, I need to eat, so I'm going to buy food. But so you could just take it as a given that I'm not going to starve myself. I'm going to actually buy food at the grocery store. I'm looking for the particular label on there that has the K with the circle around it. And I want to make sure that it's consistent with my faith. The government is supposed to review that. The government's just not. And so I'm going to buy the products and I've got a lot of anxiety because I don't know that the products in fact are prepared in a way that's consistent with my faith. If the government did its job, I would know that. You're saying that that's not an Article 3 injury.
So I think if the hypothetical consumer, if the consumer in your hypothetical wants to buy a product that is making certain representations about whether it conforms to their religious preferences or not,
right?
And they say, I really want to buy this product, I'm just not going to do it because I can't trust it.
No, they're not saying I'm not going to do it. What they're saying, I'm going to buy products and they all contain, I'm only going to buy products that contain this label, but I can't be sure that the label in fact is true because somebody could just slap the label on there and in fact it's prepared in a non-adherent way.
And if they buy the product and it turns out that the label is false, that is potentially an injury under Davidson. If they buy the product
right.
And it turns out that the product does conform to their religious preferences and they haven't.
I take the point, I totally accept the point that you'd have a more sure, more consistent, more traditional concrete injury if you in fact bought a product and it turned out to be misleading, as she did with the Purdue product. And then there's the question of whether that's the basis of a forward-looking claim. What I'm saying is let's just say that that allegation is not there because she just doesn't know if the consumer just doesn't know if it's in fact consistent with the label. But their faith requires them to only eat food that's prepared in a certain way. And so the injury that she's claiming is it's the lack of knowledge about that that's giving me anxiety. I don't know whether the food is prepared in a way that's consistent with my religious beliefs. If the government did the job, I would. And I'm going to keep buying food products because I need to feed myself. But I'd like to do it in a way that gives me certainty that in fact it's being prepared in a way that's consistent with my faith.
I have not seen a case that the other side has cited that would suggest that amount of angst and uncertainty by itself would be an injury. But at the end of the day, I don't think this court needs to get there for a number of reasons, just because we are making a lot of assumptions about what allegations are here and what's not. I would concede that would be a trickier set of facts. But again, I don't think that the courts have recognized that kind of injury just based on that kind of uncertainty or angst by itself is an arbitrary injury.
It's going to seem like a merits question, but I'll try to back into justiciability. Why isn't the government reviewing this cartoon or graphic, whatever it is? The statute requires review of written, printed, or graphic matter. This would seem to be a graphic.
So I'll say I'll respond in the same way that I did to Judge Pillard earlier, which is that, I don't want to get out ahead of my skis on this because just given where we are in the pleadings, I mean, we dispute the central allegation that's here. I mean, we understand that our own applicable regulations require us to review imagery, and we dispute that or not.
Yeah, that's fair, but I mean, the harder part of the case for you is labels by other manufacturers, right? And one reason we might not want to get into that is if there's more nuance in the question when something that looks like a graphic may or may not be, and we're thinking your friend on the other side says, well, issue an order that the government review graphics. I mean, if that's a discrete, clean, well-presented legal question, the reasons we might be comfortable doing that, considering an order like that in this case, it's less troubling than if the different pictures of other manufacturers that aren't before us just raise a lot of fact-intensive questions.
I think there are a lot of fact-intensive questions here. I don't want to sort of be out here making representations.
Can you give me a little bit of a sense of when it is or isn't a graphic?
Give you a sense of
why we shouldn't go beyond the one picture that's before us?
Sorry, are you asking whether the particular cartoon in this case is a graphic? Sorry, I wasn't.
Yeah, or why might this one not be a graphic? And I mean, the allegation is you're not reviewing it.
I understand. I mean, I want to be careful not to make any kind of representations about how exactly the agency is reviewing particular graphics in case we're not there.
Is there anything you can say?
Well, I think, in some cases, just when there are graphics in a label, it's not necessarily making a representation. It can just be marketing puffery or something like that. It's not necessarily making a claim about what the product is or is not, anything about the product. But I don't want to say anything more specific beyond that.
Appreciate it.
I wanted to give you a chance, if you had anything to add, to respond to the tail end of my set of questions about how one gets standing, which was about the sort of basic economic logic that if this graphic communicates a free roam, non-textual, even better than the textual categories, it could be commanding, it would stand to reason that it commands a higher price than Purdue's, other than fresh chicken breasts. Why is that not alone enough, even by a consumer who now knows that it's not free roam, because others might be looking at this and willing to pay a premium, and therefore she is harmed by the artificially elevated market price?
Maybe. I mean, I don't know enough about the market prices of organic chicken or anything else, just in part because it's not alleged in the complaint. And so I don't want to make any, and I think at the end of the day, she hasn't really alleged, I know this is not a satisfying response to your honest question, but the complaint doesn't really allege anything about paying a premium or not. And so I think
it seemed like it would be traditional injury under TransUnion or anything.
If she paid a premium
because the product presented itself as something better than it is. For example, if you took, DC tap water and bottled it in a bottle that had, pictures of a, verdant rural spring and, marketed it at a high price compared to like regular tap water in a bottle.
Yeah, I mean, I see that, I
Right?
see how that, I mean, it's possible that that could present an injury to seek damages, not necessarily injunctive relief, would depend on the allegations here. But again, the complaint is not alleging anything about the price of Purdue versus any other products. And so I don't think that would provide a basis for reversing the decision below.
Thank you, Mr. White. Mr. Waltz will give you 2 minutes for rebuttal.
Thank you. I'd like to just first start with a response, I think, to the hypothetical you raised, Chief Judge Srinivasan, about if Ms. Straka or if someone just does not know whether a label or an advertising is accurate or inaccurate, whether that's injury. I think I heard the answer was no, that isn't an injury sufficient for standing. Sorry, TransUnion. TransUnion, I think, says that looking to this Congress's sort of the statutory scheme can be helpful, not dispositive, but helpful in identifying what's a legally cognizable interest. And the purpose of the PPIA is to protect the health and welfare of consumers from poultry products that are ensuring that they are not that they are properly marked, labeled, and packaged. So we're in a statutory scheme that seeks to protect consumer interest in accuracy of labels. I think that helps inform whether the injury is sufficient, is a legally cognizable injury. And then I just wanted to quickly echo what Judge Pillard was saying about this sort of odd standing doctrine we're in. We've thought about we've alleged in the complaint that ALDF has 300,000 members, and many other members purchase chicken products, even Purdue chicken products. But one of the challenges is should we reach out or should we to a member and ask them to be a declarant while they may have standing because they currently do not know that the Purdue chicken they're purchasing is misleading. The minute we ask them to be a declarant and we tell them that, all of a sudden they moot their standing or they potentially lose their standing under this theory that if you know that the product is misleading, you'll never buy it again. And we believe that the sort of the Davidson theory of consumer confusion, which applies even more stronger here, helps get around that really odd work of the doctrine. Thank you.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 23-5025. Afghan and Iraqi allies under serious threat because of their faithful service to the United States on their own and on behalf of others similarly situated versus Antony J. Blinken et al. Appellants. Mr. Platt for the appellants, Ms. Hirose for the appellee.
Good morning, counsel. Mr. Platt, please proceed when you're ready.
Thank you. Good morning. May it please the court. Stephen Platt for the United States. The court should reverse the district court under Rule 54. The district court erred in placing excessive reliance on the 9-month timetable in the acts, an over-reliance which infected the rest of its track analysis. There is no need for this court to look at the former injunction or any forthcoming injunctions. The de novo Rule 54 question before this court is simply whether the agencies violated the APA in November 2022. And the agencies then and are now processing SIV applications at a reasonable pace. They faced historic challenges, which they've reacted to reasonably, and they've also acted reasonably through their own measures of their own initiative. And the results are reasonable. General downward trajectories in average processing times, all while the injunction has been stayed. The court should hold that there is no APA unreasonable delay, reverse, and return this matter to the agency, subject, of course, to the oversight of the executive and the continuing and substantial reporting obligations for Congress, whether under Rule 54 or 60.
Do we, Mr. Platt, have any information about how many pending applications from the original class members still remain pending?
That information is not in the record, Your Honor, and that I think would be difficult to assess given just how dynamic this program is. There are people entering the class every day, leaving the class every day. As far as we're aware, this is the first class action unreasonable delay case that this court has seen with individual agency actions for each class member that are being challenged.
How about for Iraq? Because there's nobody being added in Iraq, right?
That's correct, Your Honor. Congress has not extended the deadline to basically enter in the program. I believe that there are only 79 individuals still in the program, or at least 79 members, were in the last congressional quarterly report from the one that was released last week.
Now, the report wouldn't reflect, though, it would reflect everybody, even if during the reporting period, the delay, the case was sort of in their hands, it would still be reported.
It would be reported if the agencies took action on their applications and closed out a step. It reports it by step.
So all of those applications were submitted, the Iraqi applications were submitted no later than 2014.
Yes, Your Honor.
And there are still 79 that have not been processed.
That's my understanding, Your Honor. And just in the last quarter on which there is a report, the report released last week, the agencies reported that for some of the longest pending applications were closed out, such that when you remove those individuals, the average processing times for the Iraq program it was simply down to 14 days.
So I'm sorry, what was done in 14 days?
That is the average processing time when the longest pending Iraqi not class members, but Iraqi SIV applicants are removed from the equation.
Can't you always, seems like you could always reduce the average by taking out the worst case scenarios. No, is that just what you're saying?
That is true, Your Honor, but I think that goes to show that the Iraqi program, which has had generally downward trending processing times, is in even better shape than just the aggregate 15 months, which is what the agencies reported for the entire Iraqi program as of the report released last week.
14 days from when? I mean, they've already been 9 years. I'm not following what that 14 days refers to.
Sure, and if I may, thank you. And so what I'm referring to, Your Honors, is on page 6, going on to page 7 of the report released last week, which is that when you remove cases pending from
JA.
This isn't in the JA, Your Honor. This is in our supplemental notice, which we had filed last week, reflecting the newest released reports. And on page 6, going to page 7, the other 16 cases closed with an average processing time of 14 days. That was what the government or the Department of State was able to accomplish within this quarter for those applicants. And so overall, I'd like to talk a little bit more about the track analysis factor 1, which alongside.
Let me just back up before you get into that. So as to the class, so only class members are covered I'm sorry. The plan that's in place only covers the SIV applicants who had applications that had already been pending for 9 months as of the summer of 2020.
Yes, Your Honor, with just the caveat that the plan has been stayed. But yes, that is the plan that is still, the plan has been stayed since October.
Right. But the existing plan is the only injunction in the case.
Yes, Your Honor.
And as to that injunction, which was premised on the unreasonableness of the delay was measured as of the summer of 2020.
The unreasonableness of the delay was measured, well, the district court issued its opinion in September 2019. The proposed injunctive plan, which eventually was adopted by the court, was filed in, I believe, April of 2020.
Right. So the determination supporting the plan that is now before us, the unreasonable delay determination, was made as of 2020.
The unreasonable delay determination that the district court is relying on, the order that's on appeal, is from November of 2022.
That is on the Rule 54, but I'm just going back and saying the underlying circumstances that support the adjudication plan was a determination as of 2020 that all of the individuals whose SIV applications were subject to the adjudication plan had claims that had been pending for more than 9 months, and that constituted unreasonable delay. And therefore, they were put into the adjudication plan. Is that right?
I think I would disagree in that the unreasonable delay determination was as of September 2019, but
the unreasonable determination as of September 2019. And then there's a remedy that's the adjudication plan, which is the injunction, the original injunction. The government appealed that and then decided it wasn't going to appeal the track factor analysis in support of that, right? But I guess my question is, how did any of the events that the government identifies, all of which occur after May 2020, how can that reach back and render reasonable delays which were already unreasonable as of 2019, 2020? They were unreasonable. So I just don't understand how you can now say that the plan should be completely vacated because somehow those delays have been rendered reasonable.
So, Your Honor, the government isn't arguing that the court's order in 2019 or in 2020 were, or the court's unreasonable delay determination 2019, was flawed or is on appeal. It's not. That appeal is over. That was dismissed. What we have argued before the district court is that there are sufficient changed circumstances that the district court should reopen the track analysis and make an unreasonable delay determination as of November 2022. The district court accepted that request. She looked back at track. She reweighed the factors. We disagree with the outcome, but she did agree to look at it. And so the question has become, is there now a lack of an egregious delay and unreasonable delay such that there is an APA violation that can lead to a remedy?
So any determination of unreasonable delay with respect to class members who joined the class after May 21st, 2020 is not before us. There's no injunction with respect to them because the adjudication plan doesn't apply to them.
That is correct, Your Honor, but the class is defined as individuals who have submitted these applications and have been waiting for more than 9 months. And so they are still in the class. And the question that we posed to the district court is whether there is unreasonable delay for the class.
She's waiting for a proposal of a modified adjudication plan that presumably would encompass those individuals. But when that's entered, then you can appeal that. But now what's before us is an existing plan that applies only to those class members who, as of May 2020, had already had their wait determined to be unreasonable. So any class member that joined later is not before us, are they?
Yes, Your Honor, because I think
They
there's.
are before us?
Yes, Your Honor, because the distinction between the APA unreasonable delay, the legal violation on one hand, and then the injunction on the other. Unless there is a continuing APA unreasonable delay after the court undergoes its Rule 54 analysis or 60, there can be no injunction. And so that comes from the APA itself, which says that action can be compelled only if there is unreasonable delay. And this court has noted in cases like In re Bar Labs that even if after computing the track factors and coming out with an unreasonable delay determination, there is unreasonable delay, that still does not mean that there has to be a remedy, even in that.
So let's just assume, for purposes of argument, away the new plaintiffs that have come into the class. Let's just talk about the plaintiffs who were there before, as of the first district order, and remain there, because there are definitely those, right? And as to those, the determination was made in 2019/2020 that the delay was unreasonable as to them. If they're still in the class, then the delay has only gotten longer, right? You don't dispute anything I've said so far.
I don't dispute that, Your Honor.
Yeah, okay. And so my question is, because the government effectively didn't take an appeal of the initial determination, took the appeal but dismissed it. So do we just take as a given, for purposes of our assessing whether the district court erred in the order that you want us to review now, do we take as a given that it was correct to conclude that the delay was unreasonable as of the time that the district court entered its initial order?
Two things to that, Your Honor. First of all, no, we believe that the court should not take that as a given. That our decision about the appeal is not acquiescence in the legal conclusions that the district court rendered. As far as the facts that she found, that at one stage of the appeal, this is the chief of mission or comm stage, there were 30 to 60 months of delay at minimum, just at that one stage. That shows that there have been a general downward trajectory in average processing times to what they are today. In last week's report, an average of 12 months for the Afghan program, 15 months for the Iraqi program. But what the court and the parties have been using throughout this case is just the average times. The district court did not ask for any other way to measure delay other than looking at the class as an aggregate. I mean, there's no, for example, subclasses here of individuals who were in the class at a certain time or anything like that. So looking at the class-wide, without limiting the analysis to simply
What do you say about the people who were in the class before, who were already in the class, not the newcomers, but the people who are already in the class and who now are still in the class because they haven't had their application resolved? For them, it's only taken longer. That's just a physical fact about the world. It's only taken longer. But the remedy that you seek is that any oversight, any injunction should be eliminated even as to them, right?
Because there is no unreasonable delay under the APA, yes, sir.
And even though the delay was deemed to be unreasonable at time one, you didn't appeal that, and now we're at time two, which is longer.
The average times are shorter, Your Honor, since that.
We could talk about whether the average times are shorter. I mean, I don't know what the actual fix is to this. If the average doesn't take into account the people whose claims have yet to be resolved, I don't know how much information you get from that, because you're just eliminating the people whose applications have been pending the longest and who would raise the average if there were even a projection as to how long it might take us to them. If there's no number in there as to them, the fact that the average has gotten shorter with respect to the people whose claims have already been resolved only tells you so much. It might tell you something, but it only tells you so much, because it could be that there's a ton of people whose claims are still out there and who are going to have to wait 40 years. And then you would still say, well, yeah, that's true, but the average has gotten shorter because if you only look at the people whose claims have been resolved, the time has gotten curtailed. That might be true, but if there's a ton of people out there whose claims are still pending 50, 60, 70 years down the line, the fact that the average has gotten shorter wouldn't give you a whole lot of solace.
To that point, Your Honor, I would say two things. First of all, the district court's use of the average times for everyone, we don't believe is an abuse of discretion, and the class has not argued that it was. The agencies have implemented durable measures that should provide relief for everyone all applicants, and they should be better positioned to receive a timely adjudication than they ever have been before, given the improved average processing times. And before the district court, put forward evidence that, for example, the Afghan Special Immigrant Visa Unit is dedicating 20% of its processing time to some of the longest pending cases. And so the agencies are aware of that. They are committed to this, to all applicants, not just the class. And so but track simply does not lead to a conclusion that there's unreasonable delay such that there can be any continuing injunction in this case. I see that I'm out of time. I'd like to reserve time for rebuttal unless your honors have other questions.
I'm sure my colleagues don't. We'll give the other side, we'll give you some time for rebuttal. Ms. Hirose.
Good morning, and may it please the court. Marika Hirose from the International Refugee Assistance Project for Plaintiff Appellees, Afghan and Iraqi Allies. Defendants began their presentation by confusing the standard of review for this court. The question for this court is whether the district court, with its familiarity of the voluminous record in this case, abused its discretion in refusing to terminate wholesale the injunction that it entered 3 years ago. In weighing the equities as required under any standard for reconsidering a prior decision, the district court properly considered defendants' arguments of changed circumstances with, on the other, the importance that Congress placed on the prompt adjudication of the SIV applications of Afghan and Iraqi allies whose lives are at risk because of their work for the United States. Here.
So you're arguing that we should review for abuse of discretion, not de novo. But here, the district judge did take up the reconsideration request and at least check into the track factors. So there's an indication that we should look at that. I mean, our precedents say where the merits are in fact examined by the district judge, that we should review that as we ordinarily would de novo. Is that wrong?
We understand the district court to have considered the defendant's arguments on reconsideration, but then upon reconsideration, decided not to, in fact, reconsider the prior summary judgment order or the injunction.
One way of putting it, she reconsidered, but she confirmed her prior view. And I'm thinking about our case, the Connors versus Hallmark case, where the court says when the district court resolves a 54B motion on its merits, rather than by declining to consider the proffered changed circumstances at all, then we do look at that de novo.
I think it's somewhat of a thin line between how do you consider the arguments that are brought up in a motion for reconsideration and come to a decision on that. It seems that if the court had reconsidered the merits and granted the defendant's motion, for example, we would have seen a completely different.
And if they had what, the defendant's?
Granted the defendant's motion for reconsideration.
But I guess I'm wondering, do you have what would a threshold, and maybe this is a question for the government, but what would a threshold determination not to revisit the track factors look like under Justice So Requires?
Seems to me that the Justice So Requires standard gives district court quite a lot of discretion to go about the analysis in different ways. So
you argue that she didn't need to even dabble into the track factors the way she did. And I'm just trying to imagine if she hadn't, and if she said, no, I'm not going to revisit this, what would she have considered?
She could have considered each of the changed circumstances that defendants raised and said none of these apply, none of these are tied to the injunction's beneficiaries. Which is one of the flaws of their arguments. They are not bringing in statistics that are related to the injunction's beneficiaries. They are not showing how these other changed circumstances actually affect the processing of the injunction's beneficiaries, and could have denied defendant's motion on that basis. Here, the court decided to also look at those changed circumstances as against the factors on the motion for on the track analysis, which I think is also another way to go about this discretionary analysis that the court had before it.
If the test for whether it's de novo or abuse of discretion turns at least in some part on whether the motion is granted or not, which is I think one of the factors you pointed to in response to Judge Pillard, she did grant relief in part, right?
Well, she stated that she would consider defendant's arguments and did modify the injunction in part. That's the part that expands the injunction scope. But with respect to the actual termination of the injunction, which is what's on appeal, on defendant's appeal, the court rested on the prior decision to prior summary judgment analysis as well as the injunction that issued.
But if the question is there enough engagement with the merits based on those decisions that say that it's one thing if the district court decides not to entertain the motion at all, but it's another thing if the district court decides to entertain the motion and then wrestles with it on the law, the latter instance of which would occasion de novo review, the former instance of which would occasion abuse of discretion review. Here, the fact that the motion was granted in part would seem to be indicative of an engagement of a kind, if you buy that framework, that would occasion de novo review rather than abuse of discretion review. I'm not saying that necessarily means that you can't still prevail. I'm just saying in terms of the way one would frame the inquiry, the fact that the district court granted relief in part would indicate an engagement with the merits of a kind that would potentially put it in the box of cases that would occasion de novo.
Sure. On that, the question would be where to draw the line. And I think it's a tough question because in order to actually consider defendant's arguments, the district court may have to undertake different types of analysis, decide whether to grant or deny the motion for reconsideration. So it's possible. And here, the district court considered each of the factors that defendants raised on reconsideration and said, actually, it does not change the analysis overall, the track factors. So we would argue that that's more on denying the reconsideration wholesale with respect to the termination of the injunction.
Do you agree that no matter what the standard of review we apply, that the district court's determination that the government unreasonably delayed acting on applications that had been pending 9 or more months as of May 2020, that unreasonable delay determination is not before us in this appeal?
The decision from 2019, correct, Your Honor, that is not before us. The question is the district court's determination on and its refusal to terminate that injunction.
Right. So it's the original adjudication plan is what's before us. And the district court's decision in light of the underlying unreasonable delay finding not to terminate the adjudication plan. And then on the current issue before us is whether intervening events have changed or should change that analysis.
Absolutely. Yes, that's how I would frame the question. And Judge Pillard, as you were saying before, the purpose of that adjudication plan, the injunction, was and is to adjudicate that fixed universe of SIV applications that were pending as of 3 years ago, pending for over 9 months. And there's no dispute that those cases remain to be adjudicated. Defendants stated that it might have been hard for them to put in those numbers, but they chose not to do so. And in fact, the injunction requires them to process those cases and report on the progress. So it really should not be that hard to do.
Do you have any sense of how many, other than the Iraqi applicants, as to whom Mr. Pratt gave us a figure, how many of the applicants, the Afghani applicants from the original that are subject to the adjudication plan remain pending?
We don't. The latest report that we have is from July 2021 and for that report, there were still thousands of applicants remaining, even at earlier stages of processing. But because the injunction has been stayed since then, we have not been able to get more updated numbers.
Those are thousands that, not people who came in, not people who applied after the district court's initial ruling. Those are thousands that remained, that whose applications were pending at the time of the district court's initial ruling and remain pending.
That's correct.
Assume we review a renewed track determination as of the 54B ruling. Let's talk about factors 1 and 2. The statute, it has a shall, which suggests something mandatory, but what follows the shall is a very open-ended goal that would be hard to judicially enforce, improve efficiency. And then it has something that's much more concrete, like the 9-month target, but that's preceded by a should, which is generally aspirational. So if you have an aspirational goal in a provision that operates in a context where executive discretion would, we would presume it's preserved as much as possible given the national security and foreign relations overlay. Why would it be unreasonable? Why is it unreasonable if my numbers are right? As of 2022, the average delay is something like 587 days, and we have DaCosta in a somewhat arguably similar context, saying even 4.5 years is not automatically too long.
Sure, Judge Katsas. I want to answer a couple aspects of your question, one about the 9-month timeline and one about the average processing times that you are pointing to. At first, this court need not decide if the 9-month timeline is mandatory or not. That's not what the district court decided. Rather, the district court looked at the context of that 9 months mark, including the shall earlier in that sentence, as well as the requirements that Congress imposed for reporting, to understand that Congress meant something when they said 9 months. And that's enough to use it as a rule of reason for purposes of a track analysis. That there has to be a way to give meaning to what Congress said and repeat it again, even during the US withdrawal from Afghanistan.
Means something, but means less than it would had Congress said the government shall complete adjudications within 9 months.
But the court and we are not asking for the adjudications to be completed in 9 months. That's sort of water under the bridge. All of these applicants have been waiting already for 9 months, and as to the 2020 injunction for 3 more years beyond that. I want to get to your reliance on the average processing times. As defendants highlighting of the average processing times for the Iraqi applicants demonstrates, those numbers are just meaningless generally. What their average processing time shows is what they adjudicated, what applications they adjudicated at a certain step in that quarter, and how long those applications were pending in that step during that quarter. And they do not process these applications on a first in, first out basis. So these average processing times, first of all, are not tied to the applications of the injunction's beneficiaries. And they
let me make sure I understand. You're saying that that average time measures not government controlled steps within the meaning of the statute, but some subset of that.
No, it is government controlled steps, but it's not, it omits wait time. It omits wait times. So, and they are not processing these applications first in, first come. So if they process an application that came in during that quarter very quickly, that's going to show a very low average processing time. But that's not going to account for the fact that there may be applications of the injunction's beneficiaries that are still in the waiting queue and have been. for
Am I
years.
right? I thought your first answer was going to be the average, maybe this is already clear, or maybe I'm wrong, that the average processing time is only given for those as to whom the processing is complete.
Correct, yes.
So it's like if you have a whole bunch of, kids who you're teaching to read, and you say, on average, I teach them to read within a month, and you're only counting the people who you successfully taught to read, then the average is not including people that you've been trying to teach for a year and a half.
That's exactly correct.
So it's basically cherry picking
Yes,
and giving you the average of the cherry picked best, easiest to resolve.
yes,
Okay, so, and then within that, you said the average processing times are only looking at each step. So because as Mr. Pratt said, the report is divided out step by step, and they're not recumulating to tell us the average total processing times of all the steps of one applicant within the government's control. It's basically a average processing time for a subpart of the overall process. So if I say, oh, the average processing time for Pillard's application was 14 days, it's 14 days at whatever step that part of the report speaks to.
that's right. And that's how they get to 18 days or however many days for the Iraqi applications, because there are no Iraqi applications now at the earlier stages. So they're not adding how long it took at the earlier stages for those applications to get to the current step.
And even as to the current step, it doesn't include people who haven't passed through that step yet.
That's right.
It's the same problem as with the entire process generally, that it excludes from consideration of the average people who haven't been processed, whether through the entire process, if you're looking at the end game, or through that particular step, if you're looking only at that step.
Yes.
Now, that does seem like a question. What's the utility of having an average if it doesn't count the ones that are still pending? But isn't it the case that the starting figure as to how long it was taking that gave rise to the remedy that you sought was also calculated that way?
No, those calculations were made by the calculations that plaintiffs submitted based on more granular data that was provided in discovery. And we were able to produce data that was specific to the class members and to calculate actual waiting time for.
So what did you do with the people then? Well, at that point, everybody's application was still pending. So how do you get an average processing time for somebody whose application is still pending? It's how long has it been pending as of that date?
Yes.
I see.
And we don't now have that information.
We don't have that information.
Then
Go ahead.
Then is it fair to say that if you're comparing the average time at time one and then the average time at time two, the government's argument is the average time has been reduced, which is a sign of marked improvement. The average time at time one, it sounds like, was figures that you supplied that were based on how long applications had been pending as of that time. We don't have an average processing time for completing it because the applications hadn't been completed. All we had at time one was how long it had taken so far, an average how long it had taken so far. At time two, we're not talking about the ones that are still pending at all. We're only talking about the ones that have been completed. And based on the figures, the government has decided to show improvement. And so is it the case that we're not comparing apples to apples? It's not just the fact that the second apple in the apples to apple is flawed under your argument because it doesn't take into account applications that are still pending. It's that you're not comparing the same things from the starting figure and the ending figure. Is that true also?
That is true. And defendants did submit their average processing times at the time of the initial summary judgment motion, but the court credited and relied on the number. So those numbers are not the same numbers that defendants.
Okay.
And this maybe goes back to the issue of how much into the merits the district court got. We did ask that if the district court were going to go into the merits and actually reconsider, that we would be given a chance to conduct discovery, submit our fuller record of evidence. The court did not decided that that was not needed, that it could decide based on the arguments presented that there was no to revisit the determination that it previously was an injunction that issue.
But then that's with respect to whether the injunction is going to be eliminated altogether. But with respect to the remaining proceedings before the magistrate judge, there still could be discovery, I take it, about whether the parameters of the original decree ought to be modified to take into account some of the developments that the government has pointed to.
Yes, Your Honor, and there has been discovery and that those proceedings are pending.
Let me just circle back and pin down. I struggled a bit with this whole question of the appropriate standard of review. And you argue that we should look at this as if it's a Rule 60B and a motion to terminate injunctive relief. On your theory, does Rule 60B apply to a motion to terminate a preliminary injunction?
No, I don't believe so, because 60B speaks of final judgments and orders. This injunction is a permanent injunction. It's final. It's not
Except that the context in which it comes up is interlocutory. We don't have a final judgment in the whole case. And so the reason that there's jurisdiction for appeal is 1292A, and it's coming up because it's a mid-case order, injunctive order, and presumably preliminary injunction would fall in that category, but so does this, no?
Well, it is this motion, this appeal, excuse me, is certainly coming up on a motion on a refusal to dissolve an injunction.
1292A.
Of course, there is a basis for that. The words that are used in each of those sections are slightly different. So it's a final decision for purposes of appeal. 60B speaks of final judgment, orders, and proceedings, which is quite a lot broader than what Rule 54B speaks about. And Rule 54A actually defines judgment in terms of. So the injunction was appealable. The permanent injunction was appealable at that time, and it was final in the sense that it was entered after a summary judgment order.
But it was appealable not under 1291. It was appealable under 1292A1.
Well, this court did not decide that question on the prior appeal.
Do you take the argument? Do you think that could have been appealed under 1291 as a final?
Possibly, it speaks of final decisions. Again, there's some tension in the words between these different rules, and could not find a case that was exactly on point for this procedural posture. We would say that whether Rule 54B or Rule 60B apply, they both speak in terms of equities, and they're intended to give the district court flexibility to revisit prior orders. With Rule 54B being more flexible and Rule 60B being slightly more limited. So there was no legal error or no abuse of discretion in the district court holding that regardless of which standard applied, the outcome would be the same. Judge Katsas, I wanted to go back.
Sorry, go ahead.
Sorry, go ahead. Go ahead. I was going to go back.
How could it be appealable through 1291? The case is not over and the injunction is not collateral to the merits. It is the merits.
Well, so we're in this procedural posture of having a permanent injunction that was issued in mid-case. And so I think the question is, what are the right rules that apply in that circumstance?
But it's a permanent injunction. It is a permanent injunction. It's not a preliminary injunction, but it's a permanent injunction as to one claim in an action that has more than one claim. And that just seems like that's classically a Rule 54 heartland, where you have one claim that's resolved, other claims that haven't been. And what 54 says is, unless the district court does the certification as to that one claim, then the case remains pending. Now, it's still appealable because every injunction is appealable, whether preliminary or permanent, under 1292A1.
It just leads to an awkward result to apply Rule 54B, because otherwise the victorious party would have to apply for an unnecessary Rule 54B certification in order to achieve finality. And it would also allow defendants to revisit that order on a lower standard, even after the final injunction has been has gone into effect, that they've started complying with it. All of the reliance interests have started to take place.
Except it goes the other way too. If the defendant is having to comply with it, if it's rendered final, then it seems like having a prompt opportunity under de novo review to appeal whatever the question is, that's the time to do it. Otherwise, they effectively lose the opportunity for the de novo scrutiny.
Sure, and there's no question that they had the opportunity to appeal at the time, but they did, and they decided not to pursue it. I think the question is when, even though they had that opportunity, they moved to reconsider that permanent injunction, should the more stringent standards of Rule 60B apply or the more flexible standards? It's an interesting question. I don't think the panel needs to reach that question here because the district court did not reach it and decided that even under the more flexible standards, there was no need to revisit the prior decision. To go back to DaCosta for a moment, because I know Judge Katsas has mentioned that case, there are a couple of differences between this case and the other. And one is really that Congress took a rare step here of specifying a timeline for the adjudication of an immigration application, knowing that it implicates national security interests on both sides, because also following through on our promises to our wartime allies is important. And Congress has repeatedly reiterated that timeline, including through the changed circumstances that defendants claim. And the other difference is that this case is structured and has been structured from the beginning to avoid the line jumping concerns that this court has expressed in a number of unreasonable delay cases. What the court issued was a practical and flexible remedy that allows the government to explain any failures to meet performance standards. And it was a remedy that was crafted from the beginning to balance the changed circumstances that might arise as the injunction takes effect. We ask the court to affirm the district court decision for these reasons, and we further respectfully request the court's prompt decision on appeal as the injunction is currently stayed, and the injunction's beneficiaries deserve a meaningful remedy as soon as possible.
Thank you. Let me just ask you, you said that the remedy was structured to avoid the line jumping problem because there is no first in, first out line in this case, but that also seems like that's been problematic because the government is in effect cherry picking and processing a lot of the easier cases, and some of the longest languishing SIV applicants remain languishing. That's just in the nature of the relief.
That affects defendants' presentation of the facts. We are fine with defendants prioritizing in the way they want to, as long as they are processing these cases to a prompt adjudication as required by the injunction.
Thank you, Ms. Jerez.
Thank you.
We'll give the government, Mr. Platt, only 3 minutes for rebuttal.
Thank you, Your Honors. The agencies are proud of the improvements they have made in processing times, and the district court called them, quote, laudable. I want to emphasize, though, that track is about so much more than just the bottom line processing times. This court also has to consider, as part of the flexible rule of reason, why the agencies are taking the time that they are. The district court made findings about, quote, an array of diplomatic, logistical, and other hurdles, end quote, pertaining to conducting interviews abroad, especially with the fall of Kabul and the suspension of diplomatic and consular operations by the United States in Afghanistan. Because of the fall of Kabul, the district court found that case inquiries surged 816%, and the number of cases grew by 443%. This is on page 996 of the JA. As a result, the district court found that the government's task had undoubtedly become more difficult, and that's in addition to other difficulties that the district court recognized, such as...
She was very sensitive to your concerns, and she made clear that all of that will count in your favor when you go back and work out the details of a new plan. Why is that an abuse of discretion?
Well, we would respectfully disagree that it's abuse of discretion is the standard here. It would be de novo, and on these facts, the result that the district court should have reached is that there is no APA unreasonable delay.
Why is it de novo? Assume I agree with you that she redid the track analysis. And then we just have an appeal from a finding of unreasonable delay. But that finding reflects a balancing of all these fact-intensive considerations that are cutting in opposite directions based on a record developed in the district court. That feels like the kind of thing we would review deferentially.
So, Your Honor, and we do maintain that the district court picked up our motion below and adjudicated it. There was no denial of discretion to reconsider the motion. The court, for example, did not say that justice doesn't require.
I agree with you. I'm just saying our review might be discretionary, even assuming she redid the track.
So we believe that it's de novo because track cases are reviewed de novo. I mean, that comes from cases like Cobell versus Norton, and under the Trebelsi decision.
Cobell said the statement of the legal standard is de novo. Okay, she stated the 6 factors from track. She correctly stated the legal standard. And then we have a mixed question of whether she correctly applied it to this record. I'm not sure the mixed question has to be de novo.
So we believe that on balance, everything put together points to a finding of, or excuse me, a conclusion that there is no unreasonable delay. I think most notably with factor 2, which this court can and should pick up and review de novo, whether the court correctly interpreted the acts and how the 9-month timetable was used in those acts. I mean, just from the very first page of the memorandum opinion on page 989 of the joint appendix, the court identifies the classes, those people being, quote, pending for more than 9 months despite Congress's instruction that they should be processed within that time. And then the 9 months figure recurs throughout this decision. But the court, as
she didn't say it was mandatory. She gave it effect, sort of softer effect as ruler. She said that cuts against you, but as one factor of many, and she balanced that against everything else in the case.
So we believe that that balancing was reversible error, because if this was truly construed as it is, which is just a precatory deadline in light of the should, the fact that it's coupled with the shall improve efficiencies language, the section saying that a national...
So you're trying to ask us to review the unreasonable delay determination underpinning the, existing adjudication plan, but I thought that's not before us. You abandoned the appeal on that. You had a 60-day time frame in which to appeal that. You didn't appeal that. So the only thing you're appealing is the effort to modify the plan, the adjudication plan, not the underlying determination of unreasonable delay.
So we are not challenging the injunction under Rule 54B. We are challenging it under Rule 60B, that it's not in the public interest to maintain that injunction, even under a stay, or to entertain any forthcoming injunction. But under Rule 54B, the question is, have the circumstances changed such that in November 2022, there is unreasonable delay as measured through track? And the answer to that is no. Given that you have a precatory 9-month figure, you have average processing times, which are getting very close to, and at some points we're at about 9 months. And then you have everything else, the competing priorities, which the district court did recognize. She didn't find, for example, that those weren't actually things.
Suppose that the average is close to 9 months because that's the average for all the new applicants that come into the class afterwards. But suppose that it's a fact about the world that the existing class members, if things stay as they are, the pre-existing class members, if things stay as they are, wouldn't have their applications resolved for 50 years.
Well,
it seemed like the injunction ought to be dissolved wholesale.
I would say, Your Honor, that under track, simply missing a statutory deadline, even if it is a deadline, let's assume, is not enough. There's no per se point, this court has said in cases like
I agree with that. That may well be right. But I'm just giving you a hypothetical where and we'll just take it as a given that there's thousands on the Afghani side who are continuing to apply. And their applications, if things just stay where they are not going to be completed. And there's no oversight. They're not going to be completed for 50 years. Does the fact that the new applicants have their average processing time at 9 months, and I'll just take as a given that it's actually 9 months, does that mean that the injunction ought to be dissolved?
If there are applicants waiting 50 years, Your Honor?
Yeah.
I would say I can't answer that question because what we would need to see is the reasons why, all of the other track factors, to see an explanation for what challenges are the agencies facing? What are they doing to adjudicate these applications? Are they acting in good faith? What is the harm to the individuals affected by the agency's operations?
But in a case in which we already know that as of the first time, when the applications had already been pending for some number of years, a decision was made that was unreasonable and the government didn't take an appeal. And so then all we're talking about is whether things have changed so significantly that the entire injunction ought to be eviscerated. And what I'm saying is, if the basis for saying that the entire injunction ought to be eviscerated, even though there was no appeal taken the first time, is that with respect to new applicants, the time frame is 9 months. But with respect to the applicants that were already in the pipeline and have already been there, nothing has changed. And their application is going to remain pending for decades unless the court maintains its oversight. That seems like a lot to accept, that you ought to just look at the new applicants and say, well, the time frame is 9 months, and therefore you ought to eliminate the injunctive relief even as to applicants whose claims had been pending at the time that the initial order was entered and remain pending and will remain pending for a long, long time, but for district court oversight.
Well, what I would say, Your Honor, is that if we're at the point where people are waiting for an average of 50 years, we would want to look at why that is occurring. It's if there's no good reason, and maybe there is, maybe there will not be at that point, then there would be an APA unreasonable delay conclusion, and then the district court could consider whether to issue a remedy. Because under In Re Bar Labs, just because there's an APA unreasonable violation does not mean that a remedy must issue. But there is no discrete time point, even when there is a statutory deadline, that there is going to be per se an APA violation. What I would also add is that in interpreting the 9-month figure in the acts, in comparing this case to DaCosta also did have a sense of Congress provision that talked about 8 USC 1571B, which says that it's the sense of Congress that certain immigration applications should be adjudicated within 180 days. And any delay beyond that was not enough for this court to hold that
there was a line jumping problem there. If the whole process is moving slowly and there is a commitment in that case by the agency to in fact, their rule of reason was first in, first out. And so if the court then says, well, you sued, I'm going to put you in the front of the line, that doesn't actually fix the overall problem, does it? So it's a very different situation from here, where there's an adjudication plan and the government retains latitude to effectively cherry pick and, put through the people who can be dealt with quickly, even as it delves more deeply into the people whose case is language. It seems like that's a pretty significant difference.
That is definitely one part of DaCosta that is not reflected here. That the time we're interpreting what Congress has said about timing, I think, is relevant. And the concern about line jumping, I think, is also why average processing times for everyone was a reasonable thing that the district court did, as opposed to looking at subclasses of individuals who should be able to go first. But again, to be absolutely clear, there is a lot more factors at play here, including competing priorities, all the other factors of track beyond just what the bottom line numbers are. And Chief Judge Srinivasan, if I may address your point about without, you had said in the 50-year hypothetical, and there not being any oversight, Congress is watching this program. Congress has continually amended the acts to change the eligibility requirements, sometimes make it stricter, oftentimes make them more easier for individuals to qualify. They've increased the number of visas available through the program.
And Mr. Platt, even though the plan is stayed, the executive is continuing to process these applications, is it not?
Oh, absolutely, Your Honor. And so the Congress is watching this program and has access to these reports that the agencies, regardless of any injunction, are required by federal law to create and post on their websites, in which they do, in fact, as recently as last week. Unless there are any other questions? Thank you.
Thank you. Thank you for your argument, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 22-1210 et al. Sinclair Wyoming Refining Company LLC and Sinclair Katsas Refining Company LLC petitioners versus Environmental Protection Agency. Ms. Dawson for the petitioners, American Fuel and Petrochemical Manufacturers. Mr. Homestead for all other obligated party petitioners. Mr. Perdue for the biofuel petitioners. Ms. Kimball for the respondents. Refiners' arguments regarding volume requirements and percentage standard formula. Ms. McCusker for the respondents, all of biofuels arguments and supplemental standards. Mr. Brigado for the interveners, API and AFPM.
Good morning, counsel. Ms. Dawson, please proceed when you're ready.
Good morning, Your Honors, and may it please the Court. Elizabeth Dawson presenting today on behalf of the obligated party petitioners regarding the majority of the issues briefed, after which my co-counsel, Mr. Homestead, will address the issue of using 2015 and 2016 RINs for compliance with the supplemental standard. I'd like to reserve 1 minute of my time for rebuttal. In promulgating the 2022 Renewable Fuel Standard, EPA was finally forced to grapple with what obligated parties have known all along. The RFS program simply cannot achieve Congress's lofty goals. But Congress anticipated this might be the case and included in the RFS program a reset provision requiring EPA to promulgate new applicable volumes based on a review of how the RFS program has worked in the real world. Despite this mandate, EPA continued to increase renewable fuel requirements for 2022 to unprecedentedly high levels, disregarding the statutory criteria in favor of a policy of significant growth. In addition to this error, EPA also promulgated a rule reallocating hypothetical future small refinery exemptions onto non-exempt obligated parties, and further erred in a misguided attempt to respond to this court's remand in Americans for Clean Energy versus EPA by promulgating an additional 250 million gallons of renewable fuel requirements in response. But as the court reminded in Americans for Clean Energy versus EPA, Congress did not intend to pursue its goal of increased renewable fuel generation at all costs. Because EPA lost sight of this fact, EPA erred, and the court should grant obligated parties petition. First, I'd like to address how EPA misapplied the reset criteria. And to do so, it's useful to remember how we got here. So the Clean Air Act set presumptive annual volumes of most renewable fuels through 2022, but provided EPA multiple authorities to waive those volumes under a number of circumstances. Congress also realized that if EPA found itself using these waivers and waiving volumes by a certain amount, 50% in 1 year or 20% for 2 consecutive years, the statutory tables would need to be modified going forward. That threshold was crossed for cellulosic and advanced biofuel in 2010 and for total renewable fuel in 2019. So now, instead of operating under this structure where EPA is trying to reach the goals that Congress set, EPA has to promulgate new volumes based on a review of the implementation of the program during calendar years specified in the tables and an analysis of a number of criteria as set forth in 754502B2 of the Clean Air Act. But instead of applying these criteria in view of how the program has worked out, And in view of the fact that the reset provision has been triggered, EPA instead chose to continue the policy of increasing renewable fuel use at all costs. EPA used the criteria to justify even higher volumes, higher than the original volumes assigned for 2020, before the pandemic forced EPA to reassess. And to reach this result, EPA committed a foundational error. EPA returned to those statutory tables as a baseline for its analysis, instead of looking to the implementation of the program as Congress instructed when the reset provision is activated. This makes no sense, since reaching the reset requirement already means that the statutory tables have missed the mark. So EPA improperly put its thumb on the scales in favor of higher applicable volume. This error is only increased when considering that EPA promulgated this rule for 2022 6 months late. EPA was supposed to promulgate this rule 14 months before the year started, by October of 2020. And in the past, EPA has considered actual fuel consumed when promulgating late. This year, instead, EPA looked to just the first 3 months to project forward, but didn't recognize that it was issuing the rule with half a year over. Lastly, EPA failed to explain how it justified these heightened requirements when the reset criteria required looking at the impacts of these requirements, not prioritizing increased renewable fuel. For example, EPA looked to increase the renewable fuel requirements to prompt infrastructure to develop, when really the criteria required EPA to look at the impacts of renewable fuel on infrastructure and the ability of infrastructure to reach the goals. In sum, in promulgating these higher than ever volumes, EPA misapplied the factors that Congress intended to return the RFS program to reality. Now, turning from those projections to the formula for turning those projections into percentage standards, EPA can't defend its decision to reallocate hypothetical future exemptions to non-exempt obligated parties. In doing so, the agency, in its own words, codified speculation and prejudgment. First, EPA identifies no statutory authority for this action. There is none. As both EPA and obligated parties have argued before this court, the statute nowhere authorizes the approach the agency took here. So EPA can't cobble together silence with a general direction to ensure that applicable volumes are met to overcome the specific statutory language that prescribes how EPA is to treat small refinery exemptions. Second, even if that authority exists, EPA hasn't sufficiently explained why something it once thought was nigh impossible is now the best reading of the statute. Indeed, this change in policy makes even less sense in this reset posture, where EPA was required to promulgate the applicable volumes with 14 months lead time. So the idea that it could possibly accurately project future exemptions in that scenario is risible. Finally, in a turn to—
Did you say risible?
Yeah, I did.
Okay, that's strong medicine, but we'll take it. Can I just ask on this one, what do you think EPA should have done with the small refiner exemptions? Should they not? I thought what they did was they took something that previously was limited to exemptions that had already been granted and then expanded it to encompass exemptions that they projected would be granted, so as to get a more accurate picture of the total amount that's going to be off the table because of the small refiner exemptions. Am I understanding the factual terrain correctly?
That's correct.
And then is your view that you just can't take small refiner exemptions out of the mix, period, regardless of whether you're talking about ones that have already been granted and ones that have been projected, or that actually the error was in adding on to the ones that have already been granted, the ones that are projected?
Well, Your Honor, in this rule, EPA only promulgated a rule addressing future projected exemptions. The past exemptions had been part of the rule, and that is beyond challenge in this particular rulemaking.
But in terms of your theory, is what you think that EPA wasn't allowed to do what it did with respect to the projections?
Well, the statute certainly does not allow EPA to project forward in the future.
And is your claim about what the statute disallows EPA to do also something that would prevent EPA from taking into account the small refiner exemptions that have already been granted?
Well, the statute does not speak to that either. Again, we can't challenge that in this rulemaking.
So theoretically, the answer is yes. That you're not drawing a distinction, in other words, between EPA's ability to take into account small refiner exemptions on a projected basis and EPA's taking into account the exemptions that have in fact already been granted.
Correct, Your Honor, because the statute only speaks to one way to account for small refinery exemptions, and that's to make adjustments to account for the use of renewable fuel during the previous calendar year by small refineries that are exempt. And that is not the provision that EPA has invoked here to authorize what it's doing. I see that I'm out of time. I just briefly like to cover the last issue. So in a belated attempt to respond to this court's partial remand of the 2016 standard in Americans for Clean Energy, EPA added 250 million gallons of a supplemental requirement onto the 2022 standard. But in addition, the statute speaks not to this possibility, and EPA can't hide behind the court's decision, which did not require the agency's approach. So for all of these reasons, we believe the court.
Isn't it a fair implication of the ACE remand that it did intend some requirement to be imposed? And if not, as it was done, what would be the preferable way?
Well, EPA had several options as it took the standard back that it could have employed, because what the court did in Americans for Clean Energy was dispute and disagree with EPA's reading of inadequate domestic supply. The court didn't conclude that it was wrong, looking at all the facts, for EPA to waive those 500 million gallons. So EPA could have taken another look at the record and in its statutory authority, and, for example, used the cellulosic waiver, which it had not invoked, to the tune of 380 million gallons, and then decided whether there was a way to address the 120 million or to exercise some other waiver authority. But it just didn't take that time. It just saw 500 million, split it in half, and added it to 2022 and now to 2023.
And if its determination was that, absent the authority that it misread, that the obligation should be met, you're not arguing for reopening 2016. They did divide it in 2 years to try to make it less onerous. Other than your argument that they should have retroactively exercised cellulosic waiver, how else should they have dealt with this?
They could have invoked the severe economic harm waiver, which had been a possibility back in at the time of the rulemaking, or it could have considered whether the 250 gallons made sense in light of the fact that it was issuing a reset rule where it was supposed to look at the overall picture of the implementation of the program.
So your basic argument is figure out some way not to require it.
I'm sorry?
Figure out some other authority under which to not require that 500 million gallons be met.
Correct. This is just a completely unreasoned adding back in what it believed this court said it erroneously did.
And I think you said they exercised their reset authority, but they don't think they exercised their reset authority, right?
No, EPA did exercise its reset authority in 2022.
But
So,
as to the 500, to the ACE remand?
as to the 250, EPA divorced that from the reset. So when EPA addressed the reset factors as to the 20.63 billion gallons, but then added on this 250 million gallons and didn't include that in its conception of the reset.
So why wouldn't the right remedy for that be a remand for them to fold that 250 million gallons in and run the analysis again?
Well, Your Honor, we think they need to take an entirely new look at how they promulgated the 2022 rule, because they looked at it with a view to increasing the renewable fuel obligations instead of looking at what was realistic. But that is a possible.
But had they done that, had they folded it in with the 20 whatever billion gallons, you wouldn't have a claim, would you? And done the analysis.
Well, we would still think that EPA would have to justify its ability to roll 250 million gallons from 2016 into 2022, which it just didn't justify in this.
Well, it spent a lot of time talking about where to put it.
Well, they considered other options, but we submit that they did not actually fairly consider the other things they could have done to address the remand instead of just adding it on to 2022. And now I'll leave the remainder of my time to Mr. Homestead, unless you.
Okay, thank you.
Thank you.
Mr. Homestead?
May it please the court, Jeff Homestead here to address just one issue. If the supplemental standard is upheld, an obligated party should be able to meet it by using valid RINs that could have been used for 2016 compliance. The only reason for the supplemental standard is to make up for 250 million gallons of undercompliance in 2016. But some companies still hold valid RINs that could have been used for 2016 compliance, but were not. These RINs represent roughly 39 million gallons of overcompliance in 2016. In
But
some
those RINs,
cases,
you refer to them as valid RINs, but the RINs by their nature, they expire.
right, they are expired.
So they
and
represent an actual, they've been separated because they represent an actual use
That's
of
correct. When I
the.
refer to valid, that means that they represented, each one represented a gallon of renewable fuel that was used during 2016. And I should explain, some companies submitted these very RINs for 2016 compliance and then got them back from EPA when EPA belatedly granted their small refinery exemptions. But by the time EPA returned the RINs were worthless. They couldn't be used for 2016 compliance. Since these RINs represent renewable fuel that was actually produced and used in 2016, commenters on the rule argued that they should be allowed to use those RINs to comply with the supplemental standard. EPA offers just two reasons for rejecting this approach. First, EPA argues that, quote, this is not permissible under existing RFS regulations. But this is just silly. Imposing a supplemental standard wasn't allowed under EPA's regulations until EPA issued a rule to do so. In the same rule, EPA should have allowed companies to use valid but unused RINs to comply with the supplemental standard. The only other reason that EPA offers is a speculation that some of the unused RINs may not be valid. This might be true, but there is absolutely no reason to believe that anyone would unlawfully use invalid RINs now when they chose not to do so in 2016.
I mean, when you say that it's silly to argue that it's not permissible under existing regulations, it's one thing to do a year-specific remedy. Or set standards. It's another thing to change the nature of RINs.
Oh, but commenters pointed out that they would not need to change the nature of RINs. Commenters actually explained a very simple way that EPA could do this by allowing companies that had valid RINs that were unused to meet a 2016 supplemental standard instead of a 2022 supplemental standard. EPA never explained anywhere in its response to comments why that wouldn't work.
Well, EPA said it would be entirely unadministrable, but they did address that.
No, it doesn't address the proposal that we actually made. They created this straw man that makes it look like it would be very difficult, but it would not be difficult, as commenters explained, and EPA could do what it's done in other cases, including a case that it was required to do in the Ninth Circuit when a court said that when a company was stuck with unused RINs, they could use replacement RINs, which would essentially replace the expired RINs with current vintage RINs. So they had easy ways to do this, but they just chose not to.
Thank you, counsel. We'll now hear from the biofuels petitioners for their set of challenges. Mr. Perdue.
May it please the court, William Perdue on behalf of the biofuels petitioners. I'd like to reserve 3 minutes for rebuttal. In the final rule, EPA set the required cellulosic volumes too low based on a misreading of the cellulosic waiver provision. In particular, when calculating the projected volume available, EPA failed to include volumes of cellulosic biofuel that are reflected in carryover. I'd like to start with the text of the cellulosic waiver provision. That provision requires EPA, when the waiver is triggered, to reduce the required cellulosic volume down to, quote, the projected volume available during that calendar year, end quote. The parties' dispute about that language is actually very narrow. EPA agrees with us that the projected volume available means the projected volume of cellulosic biofuel that is available to be counted towards compliance with the obligated parties' volume obligations. That's on page 25 of EPA's brief. EPA also agrees that obligated parties can show compliance by retiring carryover. And EPA also agrees that all RINs, including carryover RINs, represent actual physical volumes of cellulosic biofuel that have been produced or imported. The only distinction is that carryover RINs represent fuel that was produced or imported last year, not this year. But that distinction makes no difference to obligated parties when they are retiring RINs to show compliance. By retiring carryover RINs, obligated parties can count fuel that was produced or imported last year towards compliance with their volume obligations this year. So the question in this case really is, when projecting the volume of cellulosic biofuel that is available for compliance during 2020, for example, does EPA have to include all of the cellulosic biofuel that is available for compliance during 2020, even if some of that volume was produced or imported during 2019? And that question should answer itself. The projected volume available means all of the projected volume available.
Although under 754507D1, the provision starts talking about projected volume of cellulosic biofuel production. And then later it talks about the projected volume available. Why isn't it at least reasonable to read the projected volume available with reference to the introductory clause talking about projected volume produced, projected volume of cellulosic biofuel production? So, I mean, the difference, it seems to me, between EPA's position and yours is you're talking about what's available for compliance, and it's talking about what's available in the sense of having been produced. So so their view is impermissible?
Yes, it is impermissible. And I'd like to clarify what the interpretation you began by explaining, referencing the projected volume of cellulosic biofuel production at the beginning of that provision, that having the projected volume available refer back to that is the intervener's position. That is not EPA's position. In EPA's view, two things have to be true about this volume during the calendar year. Take 2020, for example. It has to be available for compliance. Everybody, EPA and we agree about that. And it has to be produced or imported in that year. Going to the intervener's interpretation, so their view is that the words at the end of this paragraph refer back up to the words at the very beginning. But that is, if Congress wanted to refer back, have the projected volume available to refer back to the projected volume of cellulosic biofuel production, it would have just repeated the same term, the projected volume of cellulosic biofuel production, or it would have used a shorthand like such projected volume of production. What Congress would not have done if it was referring back to production is introduce a new term, projected volume available, that uses a new word, available, that is not contained in the original term that the Congress is supposedly referring back to, the projected volume of cellulosic biofuel production.
You don't think it's possible that the reason Congress didn't use the exact same terminology is that they didn't want to leave EPA without any discretion in the matter? They wanted to use a term that gave the EPA discretion on whether to treat the term as coextensive with production or to do what you'd rather have them do, which is to take into account the carryover RINs.
I think available means available. I think there are three different volumetric terms in this paragraph. There's the projected volume of cellulosic biofuel production. There's the applicable volume of cellulosic biofuel, and there's the projected volume available. So if taking those in order, it's basically the projected volume produced, and then there's the volume required, and then there's the volume available. I think the textually faithful reading of that term of those terms is that each of those is referring to a different thing.
Another way of reading it, though, is that there is in the first clause projected and applicable, and in the later clause applicable and projected, and that the projected is talking about production and the applicable is talking about compliance. So when you get down to the sentence that we're parsing here, or the clause, the administrator shall reduce the applicable volume of cellulosic biofuel required compliance to the projected volume available produced.
So EPA's reading is that it is the projected volume available for compliance. They agree with us about that. They just believe that in effect, EPA is adding a limitation into the statute. They believe that what the statute really means is the projected volume available and produced or imported during that calendar year. I think maybe I can use the example that's on page 6 to 7 of our reply brief to try to illustrate how EPA's interpretation works and why it is inconsistent with the statute. So consider 2 gallons of cellulosic biofuel. 1 gallon is produced on January 1, 2020, and it generates a vintage 2020 RIN. The other gallon is produced 1 day earlier on December 31st, 2019, and it generates a vintage 2019 carryover. Other than that, there's no difference between these 2 gallons. They sit in the factory for a few days. It takes them a few weeks to filter through the distribution system, and eventually they're combusted in a consumer's vehicle on the same day sometime in 2020. Both of those volumes are physically available to obligated parties. Both of those volumes are physically available to consumers during 2020. The RINs that are generated by both of those gallons are available to be retired towards compliance with 2020 volume obligations. But EPA counts only one of those RINs, one of those gallons in the projected volume available. But there's just no basis for that distinction in the statute.
EPA has taken a lot of care in its rules to limit RINs to the existing year and 1 carryover year, to allow carrying over of deficits to meet in a following year. And your reading is equating last year's RIN and this year's RIN, which EPA is taking care not to do. I mean, and you know, its main argument in the rulemaking is this would require basically bottom out the RIN bank. And I understand you think that's not a legitimate objective, but it is a very different treatment of prior year RINs.
I think our only point about prior year RINs is that they are, everybody agrees with us that they are available to be retired to show compliance.
True enough.
And the statute says available, these RINs are available. So really this, you can think about the volume available for compliance is by definition equal to the number of RINs that are available to be retired. That's just what RINs are. They're a record-keeping system to keep track of which volumes of fuel are available to be counted towards compliance. Judge Pillard, you also asked about this issue of zeroing out or drawing down the RIN bank. And I think it gets to a broader point, which is that we believe our interpretation is really the only one here that gives effect to Congress's choices about how to stabilize the cellulosic market, both on the supply side and on the demand side. So on the supply side, to deal with the problem of insufficient supply, Congress created cellulosic waiver credits. These credits are a liquidity mechanism. I think that's undisputed. When those credits are available, cellulosic RINs will never be too scarce or too expensive for obligated parties to be able to comply with their cellulosic obligations. They can just buy cellulosic waiver credits. But insufficient supply is just one side of the coin. There's also insufficient demand. And under our reading, and only our reading, Congress addressed the problem of insufficient demand as well. Specifically, Congress directed EPA to set the required cellulosic volume at the projected volume available for compliance. That ensures that demand is high enough to soak up all of the volume that is available for compliance. And insufficient demand is not just a theoretical problem. It really actually happened in 2018 and 2019. Over a multi-year period, there was a buildup of the carryover RIN bank, and cellulosic RIN prices crashed from $3 down to about 50 cents. And our interpretation takes dead aim at that problem. It addresses that problem directly. EPA automatically would have set demand high enough to soak up
all of those, all of the extra supply in the form of those carryover. So EPA stresses this idea of compliance flexibility. And we understand that's a real issue, but Congress addressed it specifically and in detail in the provision dealing with cellulosic waiver credits. But EPA's interpretation leaves the program with no way to deal with the problem of insufficient demand. And if there's insufficient demand, that's a big problem for this program, because the whole point of the program is to incentivize production by having sufficient demand and having that demand increase year over year. So our interpretation is the only one that has automatic stabilizers in both directions, so that supply and demand stay in balance.
Thank you, counsel. Hear from EPA's counsel now. Ms. Kimball.
Good afternoon. May it please the court. I'm Department of Justice Trial Attorney Kira Kimball here today on behalf of EPA. With me is my colleague Caitlin McCusker, also from DOJ, and also Susan Staley from EPA. Ms. McCusker and I will be dividing our time today. I will address refiners' arguments regarding the 2022 volume requirements. I will then address refiners' arguments regarding EPA's reaffirmance of the revision of the percentage standard formula. And my colleague, Ms. McCusker, will address all of biofuels' arguments as well as the supplemental standard. EPA reasonably set and fully explained the 2022 volume requirements for total renewable fuel and advanced biofuel under its reset authority. EPA used the structure of renewable fuel volumes Congress set forth in the statute. The 36 billion and modified those volumes from 36 billion for total renewable fuel down to 20.63 for total, and from 21 billion gallons for advanced fuel down to 5.63 billion gallons for advanced. EPA did that with consideration of both the implementation of the program and also the statutory factors. The statute sets forth both qualitative assessments like environmental impacts, infrastructure development, and social impacts of job creation and rural economic development, and also more quantitative assessments like consumer costs of transportation fuel and other factors. Notably, the statute leaves EPA full discretion to determine both how to assess each of these factors and how to weigh them against each other. As this court has explained, when the statute does not state what weight should be accorded to the relevant factors and instead gives EPA discretion to make those determinations, EPA is given considerable discretion to weigh and balance the various factors required by the statute. Here, EPA can...
Considerable is not unlimited, though.
That's correct.
And so you have your RIA has this very striking chart at the beginning, and it seems very thorough in listing out costs and benefits. But it's also very striking in that it contains exactly two numbers. One is the benefit of increased energy security, which you quantify at 294 million. Another is the cost of increased fuel, which you quantify at 7 billion with a B. So where, and you know, the other huge one is obviously greenhouse gas emissions, for which you give an illustration, and you sort of ask us to ignore it, but you sort of ask us to consider it. Where in EPA's analysis what's the rationale for saying that the 294 million and other benefits outweigh the 7 billion and many other costs?
At JA 24 to 26, EPA explained how it balanced the factors and explained that the qualitative factors like the production of consumer fuel and the necessity to incentivize the program or incentivize renewable fuels.
You said it. You said we've looked at all of these and we think one side outweighs the other, but where's the explanation? I mean, the best I could find is this, bottom of 24 is cellulosic, and you say some factors such as fuel cost cut in one direction, others, such as climate change, cut in the other, and we believe those one outweighs the other. And that's a statement of the conclusion of the balancing. It's not a rationale.
So throughout 24 to 26, EPA explained that it placed a lot of emphasis on the structure that Congress set up. So Congress set up a structure that was nested and started with the cellulosic and then advanced and then total. And it retained that structure and retained that structure so that it was maintaining the structure while also considering all of the factors. And when considering all of the factors, it considered the production of renewable fuels, considered that production was directly in line with what it was proposing as the volume for the reset. It also considered that more social benefits like rural economic development and job development and the incentivizing of the infrastructure for advanced biofuels for total renewable fuels, that all of those factors weighed in favor of not reducing the volumes more.
Maybe, but I mean, your own chart shows, I don't know, 1, 2, 3, 4, 7, 10 to 15 costs, which are on the other side. Most of which are environmental costs. And what's the rationale for ignoring impacts on air quality, biofuel production, impacts on wetlands, ecosystems, and wildlife, land use change, impacts on soil and water quality from biofuel, food stock production, impacts on water quantity, et cetera.
EPA is certainly not ignoring those factors. It's considering all of
Fair
them.
enough. But what's the rationale for saying that all of that is outweighed by reduced greenhouse gas emissions? Or the 294 million in increased energy security benefits?
And also the production of the renewable fuels and the incentivizing of the structure. The whole point of the statutory scheme is to incentivize renewable fuels. So reducing beyond, and renewable fuels have always been more costly than conventional fuels. So always there's been a monetary cost to this program. And EPA explained that maintaining that structure and maintaining congressional intent was important. And so there wasn't a justification for decreasing the volumes even more down below where fuels are being produced. Which also gets to my colleague's point regarding the retroactive nature of the rule. The 2022 rule was partially retroactive, and EPA explicitly considered what volumes had been produced in that rule. It considered the fact that there had been substantial increase in production or increase in generation of RINs in 2022 versus 2020 and 2021, which is expected because the pandemic dramatically decreased volumes in 2020 and 2021. EPA fully explained its analysis throughout, and the reset volume should be upheld. I'll move on to the formula unless there are further questions on the volume. EPA also reasonably reaffirmed its revision of the percentage standard formula to address projections of all fuels expected to be exempted through small refinery exemptions. Pursuant to its statutory mandate to determine and publish annual percentage standards that ensure that the volume requirements are met, the formula takes volume requirements for each fuel type and divides it by the total fuel subject to the RFS regulation. Since inception of the program, EPA has removed an amount of fuel projected to be exempted for small refinery exemptions at the time of the rule from the total fuel in the denominator. As we approach 2020, EPA was granting more and more small refinery exemptions after the grant of the rule, and the percentage standard formula was no longer ensuring that the volume requirements were met. Accordingly, EPA determined that the way to best achieve the statutory mandate to ensure that the volume requirements were met is to project the fuel that would be exempted using the policy in place and and to do so on an annual basis in order to ensure that all fuel that's in the denominator is fuel that's in the RFS system. Because EPA fully explained this rationale, so the standard formula should be upheld. If the court has no further questions, then I'll turn it over to my colleague.
Thank you, counsel. Pesker.
Good morning, Your Honors. I'm Caitlin McCusker from the Department of Justice here on behalf of EPA. I wanted to start with the biofuels producers' arguments, then I can turn to the supplemental standard. With respect to the cellulosic waiver, EPA interpreted the phrase projected volume available during that year, during that calendar year, as it always has, to include actual fuel, not credits representing fuel from the prior year. That interpretation is consistent with the plain language of the statute and the statute's purpose and structure. And this exact distinction is the one that this court recognized in ACE. There's a distinction between actual fuel and credits that represent that fuel. A word about my colleague.
How so? Can you give us just a little bit more practicality? Because surely Mr. Perdue is right that a RIN is a RIN in the sense that it only comes into being if fuel is produced.
Sure, and this goes to my colleague's notion that we agree that the fuel has to be available for compliance. We do agree that the actual fuel needs to be RIN generating fuel. We are not reading in a limitation to the statute that's not there. The phrase itself limits itself to the projected volume available during that calendar year. That's where the difference comes in.
Well, it's available, it's just not projected to have been first made available during that calendar year, to be produced during that calendar year.
The fuel that the RIN represents, though, is from the prior year.
Yeah, no, I get that. I'm just looking at the language and sort of trying to push back on your reading. So you don't agree? It sounds like Mr. Perdue said you don't agree with the interveners that equate the volume of cellulosic biofuel production in the first clause with the projected volume available during the calendar year.
EPA didn't resolve that statutory question, whether those two terms could be construed to mean the same thing. But I do think that my colleague's point that the earlier projection referring to actual fuel is illustrative, that when we're talking here, we're again talking about fuel and not credits representing fuel. The biofuels interpretation would have this court require EPA to include RINs, which would functionally eliminate the RIN bank. This court has observed that the RIN bank is of vital importance to the RFS program and the renewable fuels market. Their policy arguments also miss the mark. There's no support for them in the record, and in any case, they're not a reason to rewrite the statute.
With respect to your reliance on ACE, because I take the point that their ACE also construed something that's somewhat analogous, but then that didn't have the textual features that the other side is relying on to make the argument that there's a difference between cellulosic biofuel production and projected volume available.
I'm sorry, could you repeat that question?
Yeah, so you rely on ACE for the proposition that there was a similar issue that came up in ACE that had to do with whether you count the RINs, the carryover RINs.
Correct.
And if you apply that same analysis here, then EPA's interpretation would prevail. And I guess what I'm saying is, but that issue in ACE didn't involve the same statutory language that is involved here. And the argument that's being made under the statutory language that's involved here is that there's two phrases that matter. One is projected volume of cellulosic biofuel production, and the other is projected volume available, and they're different. And your resolution ends up equating them.
Well, I think that it's not necessarily the case that they're equivalent. EPA hasn't always been consistent in how it's interpreted the projected volume of cellulosic production. Sometimes it's suggested that it may not include imports, which would be a difference between the two terms. But I think going back to ACE, the analogy between the two statutes is that, first of all, they're both involving EPA's effort to establish annual volumes for the year. Neither of the provisions mentions credits, which if Congress wanted to include credits, it knew how to reference those credits, which are promulgated or initially set up in paragraph 5 of the statute. They didn't make any mention to that. And it's true, there are some differences between the statutes, but I think those textual differences, the ACE court's observance of the fact that the market doesn't pursue market, or the statute doesn't pursue market forcing at all costs, and the critical importance of RINs to the program, that rationale applies with equal force to the statutory provision here.
You're also talking about the supplemental requirement?
Yes.
So you say in the final rule that the total renewable fuel obligation for 2022 is 20.87 billion gallons, the 20.63 plus the 250 million gallons for the supplemental standard. But the assessment under the reset authority only considers the 20.63 billion gallon amount. Why shouldn't the reset authority analysis have been applied to the entire?
So EPA promulgated the supplemental standard pursuant to a different statutory authority and a different rationale. With respect to the interplay between the supplemental standard and the reset analysis, I'll note at the outset, the petitioners haven't challenged the reset analysis on this basis. The reset analysis required EPA to balance a multitude of factors and establish an appropriate volume for the year. That's what EPA did. The supplemental standard was an effort to respond to this court's remand in ACE. EPA's authority to do that was based on its original authority to promulgate standards in the first instance. And so EPA viewed these as separate exercises. And although it ensured that both standards were feasible and achievable, it kept its analyses separate.
How is it reasonable to subject obligated parties that weren't even in the market in 2016 to the 2022, to the supplemental obligation in 2022?
Your Honor, EPA felt that it had to take a concrete step to address this court's remand. Any approach that it considered would have imposed some burden on some obligated parties. Reopening 2016 compliance would have been particularly difficult and likely infeasible because it would have involved unwinding years of compliance. It's also true that obligated parties have since exited the market, meaning that if EPA had imposed this as a retroactive 2016 standard, it would have been setting up the program to either fall short or would have had to redistribute that obligation across other obligated parties. So EPA just felt that that wasn't a good option, and in fact, that the approach it took was better mitigated.
Why not just max out the cellulosic waiver authority?
EPA did look at that, and it found that the application of either the general waiver or the discretionary component of its cellulosic waiver wasn't supported by the record. In particular, with hindsight, we know that the 2016 market outperformed. That means it generated 800 million excess RINs. So the notion that the 2016 market conditions would support application of either of those waivers is unfounded. And it looked at the market in 2022 and determined that the volume set was both feasible and achievable.
I asked your colleague about cost and benefit of the 22 volumes, and she rightly defended them as, you know, the agency wants to push the outer limits. And, you know, renewable fuel is good under this scheme, more renewable fuel is better. And you even said that the volumes you're setting are higher than what the market has produced. I mean, if you're saying all of that to set a very aggressive volume level, it just seems really tough to then say, like, completely divorced from all of that, we're going to just add in this other obligation, the amount of which sort of has nothing to do with what's feasible for 22.
Well, I don't know that we'd agree that it was an aggressive volume that we set. Under the reset factors for total renewable fuel, we set what we thought was an appropriate volume, but it wasn't a maximum achievable volume. And EPA did do a feasibility and achievability analysis for the supplemental standard and the total renewable standard and found that the market could achieve.
Oh, sorry, you said we acknowledge the implied conventional volume is higher than the volume of these fuels projected to be consumed in the US in 2022.
Yes,
And all
Your
of
Honor.
that is before you get to this additional obligation.
Yes, Your Honor. My understanding is that the data that they were looking at when they were setting the 2022 total volume was based on the growth that they were already seeing in the market. So I don't think it was aggressive by any means. I wanted to say a word about my colleague's suggestion that EPA could have allowed the use of 2015 and 2016 RINs. That's not the case. Doing so would have been inconsistent with the statute. Paragraph 05C provides that RINs bans have a lifespan of 12 months. Allowing the use of 2015 and 2016 RINs would have been contrary to that. Moreover, EPA explained at JA 533 to 34 that it couldn't confirm that the RINs that people had in their accounts were valid. And so the representation that those RINs necessarily represent actual fuel or overcompliance is not one that EPA would agree with.
You don't mean valid as in unexpired, because of course they were all expired. So what is the validity concern?
So EPA, the way the program works is on a buyer beware system. When obligated parties retire RINs, they are responsible for ensuring the validity of those RINs. It's not unusual that parties would have older vintage RINs in their accounts. And sometimes that happens because they determine that they're not valid. They don't actually represent fuel. And so they don't trade them any further. They don't use them for compliance. They just kind of sit in the system. And EPA explained that it didn't, given the passage of time, have the ability to go back and confirm the validity of
So
them.
can you just give me just like a little illustration of what would be the source of an invalid RIN? Just some scenario or example.
Sure, a party could hold a RIN for fuel that was ultimately exported, and that RIN would no longer be valid. It should be retired upon being exported, but if it wasn't, it would just sit in the account, and a party wouldn't likely use that for compliance.
But it's harder with the passage of time. It's just harder to check on.
Correct, Your Honor.
What's the reason not to back out once again the obligated parties that didn't exist in 2016?
I think just administrative possibility, EPA, and also consistency with the sort of theory of what EPA was doing, which is that it was imposing a 2022 standard. It was using the gas and diesel projections for the year that it used for the 2022 standards otherwise. And it just would have been, I think, inconsistent if it had backed out certain obligated parties.
Would it put disproportionate burden on the remaining parties? It's one thing you had mentioned.
Correct. I was speaking about if they had gone back to 2016, but I think that general concept would be true here too. I just wanted to say, I see I'm out of time, but one quick word about the reset, which is that there's no dispute that EPA conducted a reset analysis for the cellulosic biofuel. The argument amounts to basically that the reset analysis is required to come out in the same way as the cellulosic waiver analysis. That's not what the statute says. It doesn't incorporate the scope of the other waivers in its framework, even if that's what led to its triggering. Thank you, Your Honors. Appreciate your time. And for those reasons, we think that all the petitions should be denied. Thank you.
Thank you, counsel. Mr. Bragato?
Good afternoon, Your Honors, and may it please the court. Thomas Bragato on behalf of the American Petroleum Institute and American Fuel and Petrochemical Manufacturers. Our position is that the phrase projected volume available unambiguously refers to actual physical cellulosic biofuel produced during the calendar year that is available to be used for compliance and not credits carried over from the prior year. I think there are three textual indicators in the statute that compel that conclusion. So looking at the statute, first says projected volume of cellulosic biofuel production. Nobody disputes that that refers to actual physical cellulosic biofuel production during the year. Then it goes on to say projected volume available. We think that the repeated use of projected volume is key. It's shorthand. It's referring back to the same projected volume that's referred to in the first clause of this provision. Now, it's true that there's an additional word here. That word's available, but it serves a different purpose than the one biofuels petitioners suggest. The word available requires EPA to conduct an evaluation of whether the projected biofuel is actually available to be used for compliance. There are circumstances such as when fuel is exported or not used for a transportation fuel, which makes it not available. So available serves a narrowing function, not an expanding function, as biofuel petitioners contend. Second textual clue. The term volume is used 4 times in this sentence. Projected volume, minimal applicable volume, and projected volume. The first 3, it's undisputed, all refer to actual physical volumes of fuel. The fourth one, it would be an anomaly. There's no explanation as to why it should be construed to include credits in addition to actual physical fuel.
Well, it is actual physical fuel. It's just from a different year, right?
Well, it's not. If you look at biofuel petitioners' brief, they say that the RINs reflect physical fuel. They're not themselves physical fuel, and our contention would be that the RINs do not fall within the definition of volume, because everywhere in the statute, and this is the third point I want to make, everywhere in the statute where the term volume is used, it's referring to actual physical fuel, not credits. When Congress refers to credits, it says credits, and it does that plenty of times throughout the statute. So we think that trying to cram in credits into the word volume on its own is textually not supported by the structure of the statute. And these additional textual clues make that conclusion clear. Just a quick word about the court's decision in ACE. I think the case here is even stronger than in ACE, that credits don't count. In ACE, at issue was the word supply, and supply is not a commonly used term in the Renewable Fuel Standard statute. The court had no problem concluding that supply referred to supply of renewable fuel and not supply of renewable fuel plus credits. We have a similar situation here, it's just with the term volume. And as I've explained, volume is consistently used to refer to actual fuel and not credits. So the case here, I think, is even clearer than in ACE, that volume cannot be construed to include credits, can only be interpreted as referring to actual fuel produced during the calendar year.
Can I just ask you this one question? So the last phrase is projected volume available. One thing that Congress could have done is instead of used available, they could have used produced. And then it would have been a direct equivalence between the first phrase, for any calendar year for which the projected volume of cellulosic biofuel production, that would have been projected volume produced. But you think that it was intentional actually not to use produced and to use available because they meant to do something narrower than what's produced.
Correct, Your Honor. Congress intended to account for a situation where biofuel would be produced, but for some reason not ultimately be available for compliance purposes. Again, that could be if the fuel was exported or if the fuel was not used for transportation fuel. So available serves as a check, basically, against overestimating the amount of fuel that would actually be available for use for compliance purposes.
And would that not also apply to the first two, cellulosic biofuel production? Would there not have also been the felt need to exclude from that figure the stuff that's unavailable for compliance?
Well, in the first use of the phrase, we think it's a broader use because it's just asking about what's produced. That phrase is not asking about whether the production is in fact going to be eligible for RFS compliance purposes.
But yeah, I guess then what I'm asking is, does that make sense? If Congress is saying in a situation in which blank is less than the statutory amount, then go and reduce it. Does it make sense to think of blank as everything that's been produced, or would it make more sense to think of blank as only that which has been produced and is available?
Well, I think the text supports the conclusion that it's everything that's been produced. And I think that's in part because it's supposed to be a pretty technocratic decision with respect to the first clause. EPA is making its decision based on an Energy Information Administration estimate, and the EIA is not in the business of determining whether fuel is eligible or not. So you have this first more technocratic determination of what is produced, and then you go on to this EPA expertise decision of whether it's actually available in the second clause.
Thank you, counsel.
Thank you.
Dawson, I think you asked for 1 minute. We'll give you 1 minute.
Before you start, can I just ask you a question about the statute forbids the imposition of redundant obligations on any person in 03C1? Can you give me an example of what that's referring to?
So, Your Honor, EPA has not definitively interpreted that provision to our understanding, but we believe that the reallocation framework does run afoul of this provision in that if EPA is wrong, if EPA projects exemptions that don't end up getting exempted, then you have the original potential small refinery complying with an obligation and another non-exempt small refinery or any refinery complying with the same obligation twice. It just means effectively that EPA set the standard high. Turning to the two quick points on rebuttal. First, to clear up any confusion, we did raise the issue that EPA had to apply the reset to the supplemental on brief page 35 and clearing up confusion on EPA's part, reply brief page 18. And as the second point is, as Judge Katsas pointed out, EPA's explanation of the disparity between the costs and benefits leaves something to be desired. And ultimately, the rationale is simple, that it just wanted to increase renewable fuel. But that ignores entirely the circumstances animating the reset.
Thank you, counsel. Mr. Perdue, we'll give you 2 minutes, and because we added time for the position that's argued contrary to yours, so we'll give you 2 minutes to respond to that.
EPA and the interveners try to frame this case as being a dispute about the volume of what? Volume of fuel versus volume of credits. That's not what this case is about. We agree with EPA that volume here means the volume of RIN generating fuel. The question is it all of the RIN generating fuel or just some of it? We think it's all of the fuel that generates RINs that can be retired in the relevant year, whether they're present year vintage or carryover.
Or all of the RIN generating fuel that was produced in the year.
But let me address that directly. I think so. The statute's got three volumetric terms, and all of them are different. There's the projected volume of cellulosic biofuel production. There's the volume of cellulosic biofuel required, and there's the projected volume available. Congress used three different terms because it was talking about three different things. And I think it's important to emphasize that EPA does not believe that the last term is a subset of the first. That's not their position. That's the intervener's position. It's not EPA's. That's because in EPA's view, the first term is production, and in EPA's view, the last term includes net imports. So net imports are not a subset of domestic production. You got to include net imports, and for exactly the same reason that you include net imports, you should include carryover RINs. They are available for compliance. That's as simple as that. The last thing I want to say is just a word about ACE. It was brought up multiple times. ACE involved a different statutory provision with different statutory text as applied to a different fuel category. ACE contains some general discussion about carryover RINs, but all this court actually concluded in that case is that it was within EPA's discretion under the discretionary general waiver for EPA to consider the possibility that without a RIN bank, obligated parties might have no way to comply with the total renewable fuel obligation. That just has no application here where this provision of the statute is mandatory. And because of cellulosic waiver credits, you can't have a situation where obligated parties are simply unable to comply. Cellulosic waiver credits mean they can comply.
Thank you, counsel. Thank you to all counsel. We'll take this case under submission.